somebody.
Mr. McBride, and
When we then continue with Mr. Nhleko, there is no interruption until we finish within the 2 hours that I hope we will finish within.
thank
So, okay, I think let's deal with that application first. Remembering what happened on Monday, it does appear that this is a situation where both Mr. McBride, who was to be cross-examined, is applying for a postponement, as well as Advocate
Pretorius.
JP Pretorius SC is also applying for a postponement.
That is correct.
Okay, let's deal with that first. Do you want to place your position as the
Thank you, Mr.
Commission's legal team on record?
Thank you, Mr. Chairman. Mr. Chairman, I was given an indication by my learned friend, Mr. Matabedi, who appears on behalf of Advocate Pretorius, that it was his instruction to bring an application for a postponement. He indicated to me that there were certain issues that he felt ought to be addressed in the affidavit and had not been addressed in the affidavit of his client. I had considered the affidavit prior to that, and it was also my view that there was much that had not been addressed in the affidavit. And if it had been addressed, I felt that it would have curtailed the proceedings to a significant extent. In the context of his indication to me, I did indicate to him that if I could, if certain demands on our side could be met, I would not oppose the application for a postponement, because I believe that it may well curtail the issues. He acceded to the demands, and in that context, I'm now placed on record that as the evidence leaders, we do not oppose the application.
And obviously, in the light of that, you would adopt a similar approach to opposition to Mr. McBride's own application for a postponement, and given what happened on Monday.
Indeed, we've already placed ourselves on record as far as that's concerned, and he was granted a postponement in relation to Monday, and we hold the same view in relation to today.
Yes. No, that's fine.
As far as General Boyson is concerned, he has indicated that he's on standby. We had anticipated that if the evidence was led and he was going to be subjected to cross-examination, we would phone him once the time arrived, or more or less once the time arrived.
Yes. Okay,
Thank you,
no,
Mr. Chairman.
that's fine. I think counsel for Mr. McBride must also come and confirm that she applies for a postponement in regard to Mr. McBride.
Thank you, Mr. Chairman.
Good morning, Mr. Chair.
Good morning.
I, for the record again, place myself on record. My name is Catherine Harding, and I appear on behalf of Mr. McBride. Mr. Chair, I'm instructed to appear as I did on Monday in order to request an adjournment of the cross-examination of Mr. McBride by Advocate Pretorius's team, as was granted on Monday in respect of the cross-examination by Mr. Nhleko's legal team. I do so, as I did on Monday, on the basis of the affidavit that was filed with the Commission on the 26th. It appears at page 3650 of your bundle, Mr. Chair, bundle Y8H. The affidavit, I believe, has been provided to Advocate Pretorius's legal team, and my instructing attorneys, Adams and Adams, addressed further correspondence to Advocate Pretorius's attorney yesterday, again attaching that affidavit and confirming that I, on behalf of Mr. McBride, would be requesting an adjournment today, as was granted on Monday. The basis of the request, as you will recall, Mr. Chair, is to afford Mr. McBride and his legal team sufficient opportunity to prepare for the cross-examination by Advocate Pretorius's legal team.
Yes.
And the detailed reasons for that request are set out in that affidavit.
Yeah.
Mr. Chair, if you would like me to take you through those reasons again,
No,
I'm
it's
prepared
not
to do so.
necessary. Yeah.
On that basis, Mr. Chair, I refer you simply to paragraphs 20 and 21 of that affidavit in addition, in which Mr. McBride acknowledges the inevitable inconvenience and apologizes to all parties involved, and sets out how he tried to ameliorate that inconvenience as much as possible. I wish to re-emphasize Mr. McBride's commitment to the process and to appearing to be cross-examination, subject to having had sufficient opportunity to prepare for that cross-examination. Mr. Chair, I therefore request an adjournment of his cross-examination by Advocate Pretorius's legal team.
Okay. No, thank you.
Thank you, Mr.
Thank
Chair.
you. And then counsel for Mr. Pretorius.
Morning, Chairperson.
Good morning.
Matibedi TF, together with Advocate Madlanga and Ramaimela, we appear on behalf of Advocate Pretorius SC.
Thank you.
Chairperson, on the 27th of this month, a substantive application for the relief as more fully set out in the notice of motion was launched and delivered, and acknowledged thereof was given to us, my Lord. Chairperson, the reason why we are seeking a postponement, it's due to a number of reasons. Our client was served with a notice indicating that the cross-examination of Mr. McBride and General Boisens will take place today. However, during the discussions that we had, it became apparent that the evidence of Mr. Kuba and Sisoko will also, play a role today. The challenge with that is that my Advocate Pretorius was not given a notice, the required notice, indicating that both Mr. Sisoko and Kuba were going to implicate him. Now, it's impossible in leading the evidence of Pretoria SC that we will not make reference to the evidence of both Mr. Kuba and Sisoko. And the quandrum that we find ourselves in is that once he refers to that evidence in his evidence in chief, then the evidence leaders are entitled to cross-examine him on the evidence that he tendered. Now, what is in best interest of Mr. Pretoria SC is to bring a substantive application for the condonation and for the leave to cross-examine both Mr. Kuba and Sisoko. As the evidence of both Mr. Kuba and Sisoko is interrelated with that of Mr. McBride. So it will serve or curtail the proceedings if that is done together. And the other aspect is the fact that Advocate Pretorius SC, he was given permission to cross-examine both Mr. McBride and General Boisens. But on a perusal of the initial application, it became apparent that he did not deal with a lot of issues that he was supposed to deal with. Now, that being the case, it is very important that we should supplement his affidavit, and by so doing, that will also curtail the proceedings. Otherwise, on the evidence before the commission, if one has to apply the principle relating to how evidence has to be weighed, we respectfully submit that he will be severely prejudiced. And the other aspect is that there's an understanding between the evidence leaders and the legal team of Advocate Pretorius SC that we will address issues which the evidence leaders requires of Advocate Pretorius SC to deal with. And by so doing, we submit, and we are of the reasonable view that the proceedings with regard to the evidence of Advocate Pretorius, the cross-examination of Mr. McBride, General Boysens, Mr. Kuba, and Sissoko will be, curtailed, which is in the best interest of the Commission, taking into account, that the Commission at this juncture, operates under serious time constraints and restrictions. Unless the chairperson would like to hear me on a specific aspect, that's the case for Advocate Pretorius SC.
No, thank you. No, I don't need to hear you on anything else. I understand I have been reluctant to grant postponements unless really it was necessary, and there were strong reasons of late, precisely because the Commission has a very limited lifespan left and we need to finish the work. But the reasons that have been advanced in regard to Mr. Pretorius, I understand, and in the end, the curtailment of proceedings is in the interest of the Commission. So it's quite important that when a witness comes and a cross-examiner comes to cross-examine, the issues be quite clear so that the proceedings can run smoothly. So I'm prepared to grant the postponement, and I'm prepared to grant the postponement requested by Mr. McBride as well. I just want to say, and everybody, counsel for Mr. McBride will be hearing, and you will be hearing, that because of our determination to try and finish the work that we have to do in the Commission within the time that we have, we may have a situation soon where we require people to appear in what I call our evening sessions. That means that you might not be required to present yourself at 9 o'clock or 10 o'clock, but maybe at 4 o'clock. And when the witness who was giving evidence for the day is done, we start with somebody, maybe we need 2 hours or 3 hours, we do that, we are done. So we go up to 7 p.m. or something. So as I grant postponements, I just want people to understand that they might find that we are in that situation. Obviously, the ideal thing would be to deal with a witness who can finish his or her evidence that evening, but if they can't finish, we will have to find a way. It's just an attempt for us to find more time, because, and starting early in the mornings, we might quite often start at 9 instead of 10 now, and instead of finishing at 4, finish at 5 or even 6, because just in 5 days, if we add 2 hours by starting at 9 and finishing at 5, suddenly we have 10 extra hours a week, and that can be very helpful. So I'm just mentioning that so that people should not be surprised, not only you, but other people should not be surprised if they soon get notices which indicate that your evidence will start at 4. But otherwise, I'm happy to grant the applications for postponement, one by Mr. J.P. Pretorius SC and the other by Mr. McBride, 2 dates that are still to be determined. Obviously, whatever needs to be done urgently. I don't know whether between yourselves and the evidence leaders any time frames have been agreed, but they need to be done urgently. I don't think that the dates to which that you will be advised of are going to be within the next 3 weeks. I think they'll be beyond that. But the sooner everything is finalized in preparation, the better. But otherwise, both applications are granted and the hearing of the evidence of Mr. J.P. Pretorius SC and his cross-examination of Mr. McBride and General Major General Poison is adjourned to a date to be given, and Mr. McBride's evidence also, the hearing of his evidence is also adjourned to a date to be fixed.
Chairperson, we are indebted to yourself and also to the evidence leaders.
Thank you very much.
Thanks, Chairperson.
Okay, all right. Are you ready, Mr. Halley?
Thank you, Mr. Chair.
Mr. Ntlego,
Good morning, sir.
good morning.
Yeah, good morning, sir.
The oath you took 2 days ago continues to apply. Let's continue.
Thank you, Mr. Chair.
I don't know whether I said this yesterday, but if I didn't say it, then I'm saying it now. I'm going to be much more stricter today with regard to the proceedings. So, Mr. Ntlego, those long stories, I will only allow them if I think, strictly speaking,
Yes.
they are relevant. So you will be trying to answer questions as briefly as you can. And then, Mr. Halley, I know that from our discussion here at the hearing yesterday, you will also be looking at going to dealing with the real meat
Yes.
of the issues.
Thank you, Mr. Chair.
Thank you.
Just to finish off on two topics that arose during the course of yesterday, Mr. Ntleko.
Yeah, hello, sir.
The one related to the deletion.
I'm sorry, Mr. Halley. Is that lamp working today, Mr. Ntlego?
No, it's actually not working here, Honorable Chair, and I must also declare that I brought along Iswasho to assist me. But nevertheless, no, I'm fine. I think I'm
You
able
can
to
manage.
cope with the light.
Yes.
Thanks.
Well, I wonder what's wrong with that lamp because it's supposed to be working. So maybe during the tea break they must look at it again. But Mr. Ntlego says he's declaring that he brought Isiwasho. No, I did say that he continues to throw in these isiZulu words. Yeah, well, I know what Isiwasho is. So
Thank you, Mr. Chair.
okay. Yes, let's continue.
Thank you, Mr. Chairman. Mr. Chair, if I could refer to what is LEA4.
I must just confess, I suspect that it's just pure water and not Isiwasho.
Pardon me, I didn't catch that, Mr. Chair.
No, I'm sorry. I'm saying I suspect that what he's saying is declaring as Isiwasho. I suspect it's just pure water. Maybe he's intimidating you, Mr. Halley, so that when
he's
you
been trying
question
since the
him,
first day, Mr. Chair.
you know, Isiwasho is, I think, kind of blessed water that would be blessed by church people, isn't it? Or do you get it from traditional healers as well?
Though you also do get it from the traditional leaders.
Traditional healers.
I think it should be understood as a traditional medicine concoction.
Oh,
Yes, I think it's Washo, that's probably what you put.
okay. Mr. Halley, continue.
Thanks.
Thank you, Mr. Chair. Mr. Chair, the document that I would like to refer to next is part of a bundle of documents which we've marked or agreed to be marked as Exhibit Y8D. It's the affidavit of Matthews Sissoko.
May I confirm,
It would
Mr.
be LEA4 bundle.
Y?
So the exhibit is Exhibit Y8,
Yeah, but the bundle,
and the bundle is LEA4.
LEA4. Okay. I just want to confirm, Mr. Halley, we know that Mr. Ntlego did not apply for leave to cross-examine Mr. Kuba, but I take it that Mr. Kuba's statement and his evidence forms part of what you notified him.
I believe he
you would
has
cover.
been notified.
Yeah, okay.
If there's
Okay.
any challenge to that, understood from the address right at the
Yes.
beginning, you might recall that there was an indication that there hadn't been proper notice.
Yeah,
that had
okay.
been
No, I just
given.
want to make sure that we are on the same page as to the scope of the evidence.
Yes, indeed, Chair. As I pointed out, that he was not given the notice,
Yes,
but the affidavit of Sissoko and Kuba
Yeah.
came to his attention later, long after they've testified.
Yes,
But
yes.
he's aware of
He's
those
ready to
affidavits,
deal
yeah.
with them.
And remember what I said in my opening statement.
Yes.
That nothing really turns on the affidavit of Kuba
Yes.
and Sissoko.
Yeah.
And we said that we're not even going to waste our time to cross-examine them.
yes, no, I remember, yeah.
That's right.
Okay.
Thank you, Mr. Chair. Now, during the course of your testimony yesterday, you were speaking about the laws that were applicable to the processes within IPID and how IPID reports have to be finalized. Specifically, you were making the point, which is the point I wish to deal with for present purposes, that there was nothing in any law, to use your terminology, which required the executive director to sign any, to sign off on any reports. Now, we're speaking specifically about IPID reports. Do you recall that?
Oh, yes, I do.
Just 1 second. The heater stroke aircon, in the past few days when it was on, did you feel that it was warming up? If I say it should be switched off, does that prejudice anybody? I'll have it kept on if it does warm up, but if it doesn't, I'm
Speaking
not
for
sure.
myself, Mr. Chair,
It makes some difference.
when it goes off, well, it does make a difference.
Eh?
When it goes off, it becomes incredibly cold. I know that Mr. Nhleko
Oh,
has
is that
complained.
so? Okay.
But I would be happy if it
No.
gets switched off, if it's interfering with the ability to hear.
No, I think if both of you try to speak closer to the mic,
Absolutely,
that
Mr.
might be
Chair.
fine, yeah. Okay,
Thank you, Mr. Chair.
okay.
Now, just as far as the different legislation that governs the reporting duty of IPID is concerned, that, of course, is to be found in 3 different pieces or 3 different instruments. The one is the IPID Act, the other one is the IPID regulations, and the third is the standard operating procedures. Are you aware of that, sir?
Yes, I'm always.
Now, I'd like you to turn with me, if you will, to page, the bundle that I've referred you to a moment ago, that's Y8D, exhibit Y8D, and you'll find that in bundle LEA4. And I'd like you to turn specifically to page 1542 of that bundle.
I'm sorry. Do you say that is in bundle LEA 4?
4. That is correct, Mr. Chair.
Well, this one that I have here is LEA 1. That's the one that was handed up a few minutes ago.
What it did read in the past was Y8D on the spine, but it ought to have been corrected to LEA4 in accordance with the directives that you gave us.
My one on the spine, this one is written bundle LEA 1.
No, that's not the correct.
That's not the
It should be
one.
LEA4.
That's oh, okay, no, I'm sorry. I think no, I think I've got it here. The one written, well, it's written exhibit Y8D,
That is correct, Mr. Chair.
but it should be written bundle
LEA4.
LEA4.
That is correct.
Yeah, will your team please make sure that my bundles are written exactly what they should be written so
Thank
that
you, Mr. Chair.
there is no, so that there is no confusion. Okay, what page?
Thank you, Mr. Chair. If we can look at two different, the first page is at page 1542.
Yes.
Thank you, Mr. Chair. So if you would turn with me, Mr. Nhleko, to page 1547. But to place this in context, Mr. Chair, page 1542 indicates this to be the Independent Police Investigative Directorate Standard Operating Procedures, and the effective date is the 1st of April of 2013. You see that, Mr. Nhleko? That's on page 1542.
Yes, I think you asked me to page to 1547, and I'm at 1547.
The particular document, if you would turn with me to page 1575, you'll see there at the close to the bottom of the page that it's signed by Ms. Kay Mbeki, who was identified as the acting executive director on the 1st of April of 2013.
That's correct.
Now, we know that Ms. Mbeki is, of course, or was the acting executive director that has been mentioned here previously, before Mr. McBride became the executive director on the 3rd of March of 2014. Is that correct?
Yeah, no, that's correct.
Now, I'd like you to turn with me to page 1547. There's a definition there, the third definition that appears on that, on that page, the definition of case worker. Got it?
Yes.
And a caseworker is defined to mean any official who handles cases and includes a data capturer, a CMS clerk, an investigator, a senior investigator, principal investigator, an assistant director in investigation, a deputy director investigations, and director of investigations. Is that correct?
Yes, I see what it reads.
Now, if you would turn with me then to page 1572. 7.10, or paragraph 7.10, contains a table, and that table identifies the procedures for the completion and the closing of files and dockets. You see that?
I see that.
Now, under there, it sets out the procedure. Firstly, if you look at immediately under the heading procedure, there's an indication of what is contemplated insofar as the completion of files are concerned. And if you go down in the left column, you'll see items 1 all the way up to 5. And then beneath that, you'll see that there's a separate section which deals with the closing of files, and that is itemized as 6 to 10. You see that?
Yes, I see that.
Could you read item 1 under completion of file?
The caseworker initiates completion of a file through the supervisor after completing a case investigation report.
And could you read item 2, which deals with the obligations of the supervisor?
The supervisor reviews and assures directives and quality assures directives and reports and recommends completion to DI/PH.
And then can we look at what the obligations of the DI/PH are? And I'll take you through the definitions of those in a moment. Item 3, in other words.
Yeah, I see that.
What are the obligations of the DI/PH?
Approves, disapproves completion, and the completion register is utilized.
Now, to take you back to page 1552, we will find, sorry, just go back slightly. To 1548 for the definition of a DI. If you look roughly 4 items from the bottom, the director investigations means a person appointed as a head of investigations at provincial level. You see that?
Right.
And if you turn with me to page 1550, you'll see that the definition of a PH is a a provincial head, which means an IPED official appointed to head a provincial office.
I'm sorry, did you say that is at page 1550?
That is correct, Mr. Chair. So 3 items from the bottom.
Okay, now I see, okay. Yes.
And just to round off the definition section, if you would turn with me to page 1551. It says that a supervisor means any person who supervises a caseworker of any level. So a supervisor is not defined with reference to a job title, but rather with reference to a person who supervises a caseworker. You see that?
Yeah, I don't hear you. I'm following, Chair.
So just to complete, getting back to paragraph 7.10, it's the caseworker who has to initiate the completion of a file, and he or she would do so through the supervisor, item 1 that is, after completing a case investigation report. So in other words, a case investigation report has to be completed, and that is the process of initiation of the completion of a file.
Right.
Correct? Then the next step after that is for the supervisor to review and quality assure a directive or report, and then to recommend completion to the DI/PH.
Right.
Now, you've worked in government for a long time, and you would be familiar with how one makes a recommendation, would you not, sir?
Yes, I would be.
And where you wish to make a recommendation, you would complete either a report, in this case a report, or it might be a memorandum, or it might be some other document in which you would have the words recommended, not recommended, and if you recommend, you would encircle the word recommend, or you would delete the word not recommended, correct?
That's correct.
And you would then append your signature, correct?
That's correct.
And then when you get,
I'm sorry, Mr. Hali. I'm not sure that is the only way in which
I'm
to
not sure
make
that-
recommendations in government.
I'm not sure that it is, I'm not suggesting for a second that it's the only way. But
Oh,
I'm
it's
certainly
just
suggesting
just
that
that the question, I think, was, as I understood you, was that he worked in government for a long time. He knows how recommendations are made in government. That's how I understood you.
Yes.
And then you went on to say how they are made. I know that he answered in a certain way, but that suggested to me that you are suggesting that if it's made differently, that might not be how recommendations are made in government. And I was just saying, I'm not sure that there is no other way of making recommendations within government other than that one.
Thank you, Mr. Chair. Well, we know that the method that we've described now is a method that is used within government. Are you aware of other methods that might be used to convey your indication as an official that you accept a recommendation? Sorry, let me rephrase that. That you are in fact making a recommendation.
No, I'm not necessarily aware of any other except the submission route, as it is called.
And of course, the appending of your signature in the case of those instances that you're aware of,
All right.
the appending of your signature is a very important aspect to convey your acknowledgement that you've made the recommendation.
Okay.
And then it's got to go through to a third level.
I'm sorry, Mr. Ntlego, do raise your voice so that I can hear your answers.
Oh, yeah, no, I keep on agreeing with Mr.
Oh,
Ali,
okay,
Chair, yeah.
okay.
So,
No, that's fine. It's just that you are competing with the noise of the heater, but it's okay. Just
okay.
Yeah.
No, I'll try my best, Chair. Thanks very much.
okay.
Thank you, Mr. Chair. And then item 3 says that the DI/PH approves/disapproves completion, and the completion register is utilized. And it's got some code over there. We didn't worry about the code. But ultimately, it must be for the DI/PH to approve/disapprove completion and the completion register. So in other words, there's 3 levels before a report is ultimately approved. Would that be correct?
Yeah, no, I hear you.
Now, what we know in the case in this matter, we do know that, and we've debated it for some time over here, we do know that insofar as Mr. Kube is concerned, his particular report, being the report of the 22nd of January, was signed only by him. Is that correct?
Yes.
Now, picking up on another topic that we dealt with yesterday.
Before you go to another topic, Mr. Hali, and you may have covered this angle, but I just want to make sure. I see, Mr. Nhleko, that Workmen's in their report to you also quoted the regulation 5.1 of the regulations under the IPID Act.
Right.
And I don't know if they quoted the whole sub-regulation 1 here or not, because where they start, they don't start with a capital letter, they start with a small letter. But they quote, after collecting all evidence, statements and technical or expert reports, if applicable, submit a report on the investigation of the offense to the executive director or the relevant provincial head, as the case may be, containing recommendations regarding further action, which may include disciplinary measures to be taken against a member of the South African Police Service or the municipal police service, or criminal prosecution of such member. I think I saw it might be a full regulation 5, where the suggestion or what appears to be the position is that a report must be approved by the executive director. Is that something that you recall as having been the position? I know that you said yesterday there is no law that says a report must be signed by the executive director of IPID, but I seem to think that I saw something saying the regulations require the executive director to approve, but here it says the report must be, after all evidence has been collected and statements and expert reports, if applicable, must be submitted to the executive director or the relevant provincial head, as the case may be, containing recommendations. And maybe that might mean it. This particular part doesn't seem to say so what is quoted here, but it may be that the purpose of submitting is that he or she should approve. I don't know, what's your recollection about whether there was a requirement that the executive director should approve, whether he must sign or not sign, but he should approve the report? Do you have any recollection of what?
Just two things, Chair. I think the first one is that I think when Mr. July appears, we'll probably clarify that issue. And the reference to that particular section of the regulations. There are two processes here that should also somehow we should try and understand. The first one, the applicability of your standard operating procedures. It's more to do with internal controls, okay? Now, and the regulation, no, not the regulation, the standard operating procedure, as quoted by Mr. Hali, for an example, places an emphasis on quality assurance. Precisely because if you're the executive director, you are a supervisor, okay? So you will essentially need to satisfy yourself that the work that they would have done is complete, right? Now, that's an internal process matter within an institution. But signing off, I could, for an example, maybe let me try and make a practical example. Suppose the Honorable Chair is an investigator and reports to me. I would have to satisfy myself that indeed this report is okay, it's fine, okay? Whatever, issues of standard that I would have to look into that governs the manner in which you constituted or constructed your report and so on. Now, essentially, I would have to then say to you, it's fine. You can now refer this report to the NPA or whatever authority, okay? So that's the standard operating procedure. Now, the issue I was raising is that the standard operating procedure should not be equated to law that says it's compulsory for an executive director to sign off an investigation report.
Yeah, no, I
So
understand.
that's a distinction I was
Yeah,
drawing.
I understand that, but, must I take your response to be that it was within your understanding at the relevant time that in terms of internal procedures within IPED, the executive director would have been required to have seen the report for purposes of quality assurance? That would have been your understanding?
That would have been, yes.
Yeah, okay, all right.
Thank you, Mr. Chief. If I can,
I'm sorry, but are you saying, as far as the regulations are concerned, you don't, or you do have a recollection that your understanding was that even the regulations required the approval of the director? Or you saying, I don't remember, I don't know whether the
No,
regulations say anything?
it might require for me to have a relook at it, but I really do not recall a
Yes.
situation where regulations, because the regulations, by the way,
Yes.
they are not a
They are not
standalone.
internal.
Yes, no, they're not standalone. They
Yeah.
fall off from legislation.
Yeah.
Yes.
Okay, no, that's fine.
Thanks,
thank you,
Chair.
sir. And although we're not really dealing with this issue, but just to round off the issue on page 1572, you'll see there that 1572 deals also with the closing of files. And without belaboring the point, it follows the same process as in relation to the completion of files, where the process of the closure of the file is initiated through the supervisor. Sorry, is initiated by the caseworker through the supervisor, and then it is escalated where the supervisor has to review and quality assure the report, and then has to make a recommendation to the DI/PH, and then ultimately the DI/PH must approve or disapprove the closure of the, and in the closed register is utilized. So there's essentially a three-tier system of initiating either the completion of a file or the closing of the file. Is that correct?
Yes, I hear you, sir.
If we can turn to, I'd like to turn to an additional issue, but before I do so, I just want to make it clear that, as I understand your evidence, you're not suggesting that internally there's no obligation to comply with the standard operating procedure. That's not your point, is it?
As the term stands, standard operating procedure is precisely because you need to comply and adhere to certain standards of functionality. That's why it's called standard operating procedures.
Thank you, sir. Now, insofar as the two reports, and I'm moving on to a separate topic now, but insofar as the two reports are concerned, you will recall that, once again, that there was the 22 January report, which had been signed by Mr. Kuber alone, and there was the 18 March report, which had been signed by Mr. Kuber, Mr. Sissoko, and of course by Mr. McBride. Now, when you approached when you approached IPED through your letter of the 24th of November of 2014 and asked him for the case for the case docket in respect of the rendition matter. Mr. McBride responded by sending you the letter of the 26th of November, in which he provided you with the full case docket. Is that correct?
Yes, sir.
And pursuant to that, or rather in that document, he explained to you that the docket was, the original docket was with the National Director of Public Prosecutions.
I'm listening, sir.
Well, if you've got no recollection, then I would have to draw your attention. Sorry, if you have no recollection, I would have to draw your attention to the document.
Okay.
So if you would just bear with me.
Somebody must just make sure each time there is a reference to a different file that the witness is given the file that is referred to,
Thank you, Mr.
unless he is happy to deal with the question without looking at it. But it's better if it's made available so that he can then elect whether he wants to have a look or not.
You could turn with me to Exhibit Y7, Mr. Nhleko.
Yes, Mr. Halley, you are right.
No, don't worry.
Somebody should long have stood up to take the file and give it
Thank
to
you,
the
Mr.
witness. Yeah.
No, it's all right, Chairperson. I'm remembering some few things about administration, so I've already located the Exhibit Y7 file, and I feel so educated by being able to do so. Thank you very much.
Yeah, okay. Yes, I must say that so far I think we are moving quite satisfactorily. So let's...
I don't think we should jinx it, Mr. Chair.
Let's stick to that lane. Yes. Thank you. Just confirm again, Mr. Halley,
This is Exhibit
for the record,
Y7.
which file? Exhibit
Y7. It's one of the
Exhibit
historic
Y7.
bundles.
Yeah,
It's the supplementary affidavit of Mr. Robert McBride.
yes.
Now, if you would turn with me to page 144,
144.
that is correct, Mr. Chair.
Yes.
To place this in context, Mr. Nhleko, this is the letter that we referred to at least yesterday and the day before. It's the letter of Mr. McBride dated the 28th of November 2014, which is addressed to you as the Minister, that it's responding to your earlier letter of the 24th of November. Is that correct?
Yeah, that's correct, sir.
If you turn with me to page 144, under the heading Conclusion at the foot of that page, Mr. McBride says that in the second paragraph beneath that heading, the recommendation with the entire docket and evidential material was forwarded to the Office of the National Director of Public Prosecutions on the 14th of April of 2014. On the same day, a disciplinary recommendation was forwarded to the Office of the National Commissioner.
All right.
Did you ever follow up with the National Director of Public Prosecutions to confirm whether the whether he did indeed have the original case docket with the recommendations.
A follow-up was made, and I think that will also become much more clearer as and when we get to the testimony that would be led by Mr. July, specifically in the construction of what is commonly referred to as the Waxman report. And it will also reveal the internal communication even within the National Prosecuting Authority in regard to this matter.
So would it be fair if just to paraphrase or to try and understand your response, would it be fair to extract from that your response is that the investigation or the follow-up in relation to whether the docket was with the National Director of Public Prosecutions was in fact done by Worksman's?
It was through Waxman's investigation.
If you could turn
Chair,
with me
could I
to
just
exhibit...
declare that it's extremely cold? It's extremely cold, Chair. I'm sure this is if you're in a mortuary, this is how it feels. You know, I suspect.
Well, I can tell you that Mr. Halley told me on Monday, which was his first day of leading evidence here, that he complained of extreme cold. Now, I have been here for a few weeks now, hearing evidence, but I've had the benefit of some small heaters as well, so I might not be exactly in the same position. I think they are going to try and see what can be done. The question is whether that is making it colder, and maybe if it is, it may be that it might be less cold without it than with it.
Possibly.
The relevant person has gone out. I think they'll see what can be done. Please raise your concern again if after some time we don't feel any difference. There might not be much we can do other than switching it off and on, because it's a big venue, and therefore I think it takes time, but also I don't know how effective it is. But I have heard that sometimes people have felt at least some slight warmth. I haven't heard anybody saying it feels very warm here.
It's a question of the advantaged versus the disadvantaged.
I think we're all disadvantaged in the current environment, Mr. Chair.
Well, I see
There's
when
degrees of disadvantage.
I think when he says advantaged, he looks at me.
Yes.
Maybe because of the heaters.
Yes,
But
exactly.
quite frankly, the one I have today, I also don't. And yesterday I had two, and I think one was not effective. Today I've got one. It doesn't feel any different from yesterday. Okay, let's continue, and hopefully something will be done. I've been told this venue, the building is old. Some of the infrastructure is not good, so some of the things that one would expect are not there, because it's an old building with an old infrastructure. But let's see. I think probably you would have been well advised to put on a jersey as well. Mr. Halley, when he felt it was extremely cold on Monday, he also didn't have a jersey, but yesterday he had a jersey on as well. So I've been wearing a jersey since we started here. Okay, let's continue and just do raise your concern again later on if we continue to feel extremely cold. Yes, Mr. Halder.
Thank you, Mr. Chair. Now, as regards the two reports, if I understood correctly from your testimony yesterday, you had received the first report, that's the 22 January report, signed, and you know that it had been obtained through your internal structures, but you don't know precisely by whom. If I understood your testimony, you said it landed on your desk, and you don't know who might have placed it there. Correct?
Yes, I'm listening, sir.
And the second report, which was dated the 18th of March of 2014, that was provided to you by Mr. McBride through the letter or attached to the letter, together with the docket on the 26th of November of 2014. Is that correct?
Yes, I'm following, sir.
Now, when one considers the two reports, and it's a proposition I had put to you yesterday, but we didn't get around to fully ventilate it, but when one considers the two reports, the second report, there was no suggestion that the second report had passed itself off as the first report. The second report was a report dated dated 18 March 2014. It did not purport to pass itself off as a report dated the 22nd of January of 2014. Would that be fair to say?
Maybe let's try some simpler English. I don't know. Are you saying?
Shall I start one step at a time then? Firstly, let's look at the date.
No, I hear that part, but let me get this point correct. You are saying there is a 22nd January report, which has nothing to do with the 18th of March report. Is that
I'm
right?
not saying nothing to do. That's far too strong for what I'm conveying.
No, I'm talking about two distinct reports.
I'm saying that the 18 March report does not purport to be the 22 January report.
It couldn't be. It's dated the 18th of March. So it couldn't be the 22nd January report because it's dated the 18th of March. So that's why I was saying let's maybe try and separate the two.
Maybe let me ask this question, and I think it might go back to an issue we discussed yesterday. Is there any reason why the report of the 18th of March could not be taken as a replacement of the report of the 22nd of January?
I think, Honorable Chair, earlier on, during the days that I've been sitting in this freezing place, I briefly spoke to this issue.
Yes, but
I even referred to the question of what the convention is, even worldwide. If you produce another report that has got to annul another one, you state so.
Yeah.
You then say, look, this report annuls that one. So I'm withdrawing that one, replacing it with this one. Okay? So that's what practice and convention would have. It would also be interesting that with regards to exactly this specific issue, to get the attitude of the prosecutors in the NPA, because they spoke to this issue as well. They had a reaction to it in relation to the second report that they then received. So my clarification would be that if then that is the case, because I don't think we should be understood as saying you can't replace a report. But if you replace a report, state that you are replacing that report and it's replaced by this one. Okay, and state your reasons as to why you think this is correct. You know, I'm just making an example. I wanted to leave it at that. Chair.
No,
Thanks.
I think what you have said is it does clarify to quite a large extent what I had in mind. I think probably what Mr. Halley also had in mind, but I'm looking at him, he's not nodding, so he might, but
He hardly ever does. He hardly ever does not.
well, I haven't seen him shake his head either, so. But let me make this proposition to you, that
Yes,
what
sir.
you have said, namely, that if you want to replace an earlier report with a later report, you would write or you'd make it clear that this later report replaces the earlier one. Now, you may or may not give reasons, you know, but obviously, if the person you are conveying this information to says why, you would have to say why. Okay. You want to say something before I move on? Yeah.
No, thanks, Chair.
Yeah.
But in that regard, I think when we try to clarify ourselves around this issue, in the manner in which the Chair is doing, at the back of our minds, we should not forget, these are investigation reports, so they rely largely on what is contained in the docket
Yes.
and the statements therein.
Yes, yes.
So I would suppose, for instance, without speaking for the NPA or for prosecutors there, because I don't know how they work, regardless of the allegations that have now captured them, but the point is, certainly they would have to factor the why question when you come in with a second report that says, no, I'm nullifying the other one. So it would mean it will take them back, all of them, the investigating officer and the prosecutors, it will have to take them back to the constituting material, which in that case is referred to as the docket.
Yes, no, I understand that. I'm starting from the general before going to the specific.
Okay.
I'm suggesting to you that you may not need always to explain why you are replacing one report with another, an earlier report with a later report. But obviously, if the person you are giving the report asks the question why, you would have to explain, you know. But I'm imagining if one of my staff 11.
That's the impression I got. I thought it was incredibly generous.
No, I'm under the impression that I said, let's make it a tea break. So the adjournment would be a tea break and we resume at 11. But it's fine, let's continue now.
Thank you, Mr. Chair. Mr. Nsteko, before the adjournment, we were dealing with the question of the two reports and what it is that you would have expected a person to do if it was their intention to annul or to change a previous report. Now, you've indicated that one would have expected in the new report to indicate that you've changed in the old report. Do I understand correctly?
Yes, I think I must have said that.
Now, you're speaking in general terms. If I understood you correctly, you're saying, well, you don't know what the processes are within IPID, but if I understand you correctly, speaking generally, that is what you would have expected.
Look, if you say general terms, perhaps I would want to qualify that because, you know, in government, there are no general terms. There are practices there and conventions and regulations and laws. Now, because if you say general terms, it's as if you are referring to any other form of a report, including a newspaper report. I mean, it can't be.
But maybe because we were discussing this point earlier on, and
Yes, yeah.
I think we had not finalized it when the electricity went off. Let me also come in. This is the proposition I wanted to put to you when the electricity was, supply was interrupted. Namely that even if, or let me put it this way, is the position not that even if the person who is supposed to give you a report on a certain matter, isn't the position that even if he doesn't or she doesn't say, I'm withdrawing the earlier report, if having given you a report earlier on a subject matter, he or she gives you a later report, and the later report deals with the same subject matter, unless there is something in the later report that suggests that the later report doesn't replace the earlier report, it would be reasonable to take it that the later report replaces the earlier report. So in other words, unless the later report says, or unless the person tells you, you have got to read both, you need both. If the later report deals with the same subject matter, it would be reasonable to take the later report as replacing the earlier report. Even if they didn't say anything, if you read both, you might say it can't be intended that they both stand at the same time. One of them falls.
I like the last part. One of them falls.
The falling part.
One of the falling part. I like that.
Okay.
I like that, Honorable Chair. But the point really is that, and I think I tried to clarify this point. Look, in this particular instance, for an example, Chair, a report does not produce the docket, but it is the docket that produces the report. So it works the other way around. Now, the docket is the basis that constitutes the essential body of the report, right?
The report will be based on the docket.
On the docket, yes,
not
exactly.
the other way around.
Exactly. And I think there are wonderful points that or propositions that you also put to me yesterday, which made me think in a way, because I think it was in the process of thinking that we needed to reflect on some of these things. But I'm then saying, even if we are not talking of an investigation report, because an investigation report is a very serious matter. It's a very serious report, because it bases itself on statements collected, the analysis of evidence and whatever else and so on, albeit at a prima facie level and so on. But I also do think that the question that the chair is posing is well actually suited for the National Prosecuting Authority to respond to, right? What was their understanding, and is it their understanding based on law that you could produce a second report, and if you want to, produce a third report if you want to, and your understanding should always be that because the report is the latest, it replaces the first, the second, and the third report. I'm just making an example. I think for me, I would also be very interested in that. But I'm further saying, Chair, that, convention has it. If you produce a report, you must then state that this report that you're now producing replaces the other report on the same subject matter that you must have filed at some point. And you must advance your reasons. I mean, here, because we're talking of matters that are related to law and criminal prosecution, you would have to state your reasons why you are now changing and filing a latest report of any sort. And they would have to be congent kind of reasons, I should think. Now, and that's why I'm saying we should draw the distinction around this particular matter, but I'm also very interested to hear what the NPA itself understands by this, because there were particular reactions on the side of the prosecutors that were assigned to assist IPID in this particular investigation, in their reaction in relation to the second report.
No, I understand that part, but remember
Yes, Chair.
that, as I understood your evidence yesterday, the report is not just for the NPA, it's also for you as minister at the time, as I understood it, because you may have to make a decision with regard to disciplinary matters. So, is that correct? Is my understanding correct?
Look,
If they recommend disciplinary action, I understood you to say you would have to make those decisions in regard to disciplinary matters, but the NPA would have to make decisions in regard to
on
criminal
prosecutory matters, yes.
My understanding is correct.
Yes, sir.
Okay, so I'm saying while the NPA's understanding of this question I'm raising might also be important, but it's important also in regard to you because you were expected to make decisions in regard to disciplinary matters. And when this issue of whether the first report was final or not arises, so it arises in regard to both those who were supposed to make decisions on criminal matters and you who are supposed to make a decision on disciplinary matters.
Right.
So your own understanding becomes important. And that is why I pose the question and I invite your own understanding what it was.
Yes,
Because
sir.
the proposition I'm putting is that even if the person giving the report doesn't say this one replaces the earlier one, as you have suggested, I'm saying to you, what about the proposition that you may, when you read the two reports, see that they can't both be intended? to operate and to be valid, only one can. And in that case, I want to put the proposition that it would be reasonable to think you would say is the latest one that must be intended as the report. And therefore, in that case, it replaces the earlier one. They are not meant to be, you are not supposed to make a decision, to base your decisions on both, particularly when they have material differences. So my suggestion is that, my suggestion to you, Mr. Nhleko, is that if you give me a report today, and 5 days later, you give me another one, dated 5 days later, on the same subject matter, and you don't make a note for me to say, I must ignore the first one, and you go away. If I read both and see that there are differences, even without asking you, it's reasonable for me to think that I must take the later one as intended to replace the first one. What do you say to that proposition?
The Honorable Chairperson, I hear you, but still disagree with you.
No, this is the opportunity
yes.
to disagree with the chairperson.
I still disagree with you,
Because
Chair.
I want to understand your own
Yes.
approach and understanding how you approach the reports. So it's important for me to understand that.
I would say to you, Chair, look at it from an angle of a person who has an institutional responsibility. An institutional responsibility, and of course, in this definition, I'm deliberately excluding the NPA because I think you made a general point. So we're not talking about the specific in this regard. So, but let me also try and be general. So here you are, you're a manager, you're a supervisor, and your subordinate has filed a particular report, let's say some few weeks ago. And this subordinate says, this report, this is how it's final, and I've finalized it, okay? But then the same subordinate comes back 3 weeks later with another report on the same subject matter and does not refer to the first report and says to you, here's a report. It's as if it's a new report, okay? Firstly, that on its own, there's something wrong with that. Even that approach, completely wrong. But nevertheless, suppose I ignore that as a person who holds institutional responsibility, being a manager or supervisor of sorts. Now I've got to take a decision. The dilemma that you then have is that you have 2 reports before you, all of them valid. Valid in a sense that the first one filed 3 weeks ago has not been withdrawn, is still the same. Now you have a second one, which is not a continuation or supplementary report to the first one, because that's a different matter. If it's supplementary, it means continuation. So you now have a second one. Now, this second one does not talk to the first one, but the subject matter is the same. All you have are material facts that have been removed from the first one to constitute this one. The question is, in the execution of your duty, what do you do? Now, if you assume, if you make the assume as the chair implies, I can assure you of one thing. You would be introducing institutional instability and turmoil within that very same institution, because you are likely to then say, no, I assume that the second report is the valid one. And therefore, on the basis of which I'm making these following decisions. So you make your decisions, but your decisions are wrong because they could then also be challenged by some of the issues arising out of the first report. So your decision-making shall always be contested, and that's why you need to have absolute clarity around these particular matters. And I think yourselves as lawyers, I think you have a term that you use, an ambiguity, something like that. I think that's big English, but nevertheless, I think it's absolutely, we must have absolute clarity so that then we are correctly empowered as a supervisor and a person who's holding institutional responsibility to be able to execute your duty and function. Otherwise, that's my personal opinion on the general, of course, as per the proposition by the chair.
No, I understand you. Let me put this. I think I said yesterday, when I put to the proposition that what do you say about the proposition that the second report may have been or was intended to replace the first one, I don't necessarily mean that if you thought there was something wrong with the first report, or if you thought that arising out of you being given two reports,
right?
The mere fact that the second one is taken as replacing the first one may not necessarily mean that you can't pursue anything that you think needs to be pursued.
Right.
It's simply to say, in this context, it's difficult for me to see how you could have thought that the authors of the report intended you to regard both as valid, as continuing to be their report, because they had, for example, recommendations that were in conflict with each other. So once you know that the one report, the later report, has a certain recommendation that is in conflict with a recommendation that was made in the first report, it seems to me that logically you have to say they can't be intending that both must be taken as valid. What you may still say is, okay, I accept that the second one is your final, but there is some concern I have, and that's why I want to look into something. I don't have a problem that you say you regard the second one as final, but that does not remove my concern when I look at what has happened.
Chair, let me try and illustrate this point, maybe differently. And I'll come closer to your profession, okay? So you issue a judgment today, and this judgment is based on certain considerations and the processing up until the point of an order. 3 weeks later, I don't know why I like 3 weeks later. 3 weeks later, the same judge writes the judgment on the same matter, right? Arrives on a different order. But the matter is the same, the material factors are still the same, right? But now what you're confronted with is that right at the tail end of the judgment, you have an order. The first order looks different from the second one. Now, to a person who's the recipient of that order, what is he or she supposed to do? Which order do you then follow, right? Now, and of course, I'm not trying to say that investigation reports are equivalent to judgments and orders. But I'm trying to illustrate this point, that you shall always as a recipient of either a report and or an order like that, have a problem in terms of which is which then between the two. But you're also likely to ask yourself one logical question flowing from that issue, and that is, how come this order differs from the other? What are the material factors that brought about this? Now, and that's why I said respectfully, I probably disagree with the chair, because the example that you were making is of a general nature. It's any other report like a newspaper article, and so on. But now we're talking about institutions of governance, which have got to be, their work must be executed explicitly, boundly, and clear. You know, that's the thing. So I'm not sure what I'm satisfying the chair's.
I think we are very close to
Yes.
to seeing the matter in the same way, but I think there's just a little bit of, there's a point where we may not be seeing it exactly the same. But
Okay.
let me make this point. With regard to a judgment, judges change their judgments all the time as long as the judgments have not been handed down.
Right.
Okay. Once they have been handed down, they may correct certain things, not substance. Okay. But before they are handed down, you chop and change. Sometimes 5 days before the date when you are going to hand it down, you are going this way. And 1 day before you hand it down, you realize, no. I'm completely wrong. You go this way. So people don't know how much you agonized and took different twists and turns before ultimately you hand it down. Now, in the case of the investigation report, my understanding is that they presented the second report before you could make any decision on disciplinary matters. They presented the second report before the NPA could make any decisions. You know, so it may be that as long as the powers that we have not made any decisions, it should not be a problem. But if they've already made decisions, it might be a different issue. But I said earlier on, whether you take the report, the second report as the final one or not, I'm not necessarily saying that if, when you look at what is said in the final report and you look at what is said in the earlier report, you can't pursue an issue that you think should be pursued. So I'm working on the basis that even if you accept that the second report is final, that should not necessarily mean that you can't pursue an issue that is of concern to you, arising from looking at the two reports, but still accepting that the final one is the second one. So that's where I am. I think we are close. We probably, you might not agree, and I might be wrong, but I think we are not as far apart as we might seem.
Okay. Yeah, I hear you, Chair.
Yeah, okay, all right.
Thank you, Mr. Chair. Just to be clear about the question of the amendment of reports, etc., I'd asked you whether that was a general proposition or whether you were talking specifically about the amendment of reports in relation to IPID. But I want to ask you a slightly different question, but on the same proposition. Is there anything within government, either a statute, a regulation, or standard operating procedure, a manual that stipulates that before you amend a report, or before you produce a second report on the same topic covered by the first report, you must refer to the first report and identify to what extent and why you've changed the first report and why you've done so.
No, let me refer to practice, because I would not recall, of course, the applicable sort of regulations and or policy positions, but practice has it in government that if you produce a report as contained in what is commonly known as a submission, for an example, and something changes, whether you want to update that, you will need to produce another report in relation to the first submission that you would have made and point, and refer to it in very direct terms that this report that you're now filing is in relation to submission, whatever code of the submission and the title of the submission, and that you are amending it in respect of whatever the issues are that you would then identify in your new submission. So that's what practice is. And of course, I've not worked for each and every government department, but at least in the areas that have functioned, I know that that's the case.
And then to follow up on that, is there a rule, a practice, a statute or a regulation which stipulates that if one does not follow this practice of which you speak, that gives rise to misconduct and possibly criminal misconduct?
Chair, that really depends on what each matter would be contained in such a submission for, and the gravity thereof. I mean, really, so.
Well, I'm actually putting it at the very general level. I'm asking you, is there a rule, either a rule that's contained in some instrument, whether it be a statute, a manual, a regulation, which stipulates that the mere failure to follow this practice of which you speak, the mere failure, doesn't matter what the content is, or doesn't matter what the extent is, the mere failure constitutes misconduct or constitutes a criminal offense?
Look, Mr. Hali, it would really depend on the policy framework and outlook of each given government institution, particularly contained in your standard operating procedures. It's possible that another department, depending on what that department would be, it would maybe in the standard operating procedure refer to a misrepresentation of facts or reports or whatever the case is. And therefore, if that is so, that can then be gravitated to an area of misconduct as and when, for instance, an employee would have committed such an alleged sort of offense. So, and that's why I don't want to talk about whether rules, regulations, and or legislation in government, because I mean, really, that's very broad.
Thanks. But of course, the proposition that you advance in and the example that you use of a misrepresentation, that stands on a completely different footing. What you mean there is that when you state one thing, you're making a statement about one thing, whether it's been in a report, whether it's been a verbal statement, when that thing that you know that thing to be false, that would then amount to a misrepresentation. Whether it is a misrepresentation that is actionable in the sense that it is a disciplinary infraction would of course depend on the content of the misrepresentation and its materiality to the workplace. In other words, it's on a matter of, that's on a matter relating to your duties.
No, I hear you, Mr. Halley, but I was just making an example in terms of what could also possibly be said in a set of standard operating procedures and/or policy of a particular institution.
I want to deal with a slightly, or move on to a different topic. I mean, you were the Minister of Police. Now, one of the issues that had been raised by Mr. McBride when he came into office sometime in March of 2014 was immediately to identify, once he was told that crime intelligence had been involved in this investigation, he found that particularly strange. And if I understand him correctly, he was saying that it was strange at two levels. It was strange that crime intelligence had been involved in an investigation at all, because crime intelligence doesn't really, to use the language, carry a docket. They don't investigate criminal misconduct. Crime intelligence gathers information, they gather, and they pass it on to some of the other structures within the SAPS. Would that be a fair comment?
Look, I think it is. I think it's also a matter that in the first report of the Civilian Secretariat for Police in 2013, 2012, if I'm not mistaken, does refer to the matter having been picked up by crime intelligence and so on. And I think that's when the minister, before I came in, took a decision to then refer the matter to IPED. But also at the earlier stages, when Ms. Kuki Mpegi was the acting executive director there, there was some involvement of a person from crime intelligence in this. For how long, I don't know, but by at some point, that person withdrew. So the issue of the involvement of crime intelligence did not necessarily arise around about February or March of 2014. I think it's a matter that was there long before the conclusion of the report by Mr. Kuba on the 22nd of January 2014. So, and I think there's something that I must have seen somewhere by Ms. Kukimbegi talking exactly to that issue, a decision being taken that then crime intelligence needed to be, whomever person was there needed to stand out and away out of the investigative work that IPED was conducting.
But before I deal with that response, I just want to understand, would it be fair to say that crime intelligence is a body or a structure within the SAPS that gathers evidence or gathers information and they pass it on to other bodies or other structures within the SAPS? They don't carry dockets.
Yeah, I think you're correct, with the exception that you corrected yourself there correctly. They don't gather evidence, they gather information.
Yeah. Thanks for that correction. Now, the person you're speaking of is a certain Colonel Mukhangwe, Moukangwe, if my memory serves me correctly.
Right.
Now, in fact, Colonel Mukhangwe didn't withdraw from the matter, as you suggest. He was involved in the matter right up until the matter was being dealt with by Mr. Kuba. And he assisted Mr. Kuba throughout, and he was instructed by Ms. Kukimbeki to have Mr. Kuba or to have Colonel Mkangwe assisting him at all stages.
Mm-hmm.
Would that be, for you, would that be problematic?
No, look, I think that detail, as when my understanding is that you could be in the process, Chair, of taking a decision to invite Ms. Mbeki here, because I think she would, be well positioned to clarify that particular point.
Yeah, no, I think that Ms. Mbeki should come and testify. Actually, I was surprised that yesterday, Mr. Halley, you were told that her affidavit is still not final. About a year ago, I said her affidavit should be obtained. But I think the reason why Mr. Halley raises this with you might be the same reason that I wanted to raise some of the issues, including the involvement of Mr. Makwangwe with you. I think he raises it with you because the involvement of crime intelligence or of somebody from, well, the involvement of crime intelligence prior to, in an investigation, because as I understand the position, crime intelligence, excuse me, crime intelligence had conducted some investigation on this rendition issue before the matter was handed over to IPED. And then when it was handed over to IPED, Mr. Mukangwe from crime intelligence, or Mr. Kuba was told that he was going to conduct the investigation with Mr. Mukangwe. And it appears from Mr. Kuba's affidavit that the justification that was put forward was that because Mr. Mukangwe had done quite a lot of investigation, so he should be kept in the investigation even when the investigation was being conducted by IPED. So my concern is why would crime intelligence, who are not supposed to conduct investigations, one, conduct an investigation in this case, two, remain so interested in this investigation that one of their own must assist or be part of the investigation even when the investigation is under the auspices of IPED. So, Mr. Halley, we will say you might have a different concern, but that's the concern. There are many other fissures, and maybe we'll talk about them, which make one say, but why were things happening the way it suggested were happening in regard to this investigation? Of course, I have not heard everybody. Maybe when I hear witnesses who have not come, who have not been heard yet, like Ms. Mbeki, certain things will begin to make sense. So, but until that happens, there are certain fissures where you say, but why was this happening?
Yes, Chair.
So I think that for me, that's one of the issues to say, you having been Minister of Police, you would be able to say, well, to me, it doesn't look strange that one, crime intelligence conducted investigation on this issue at all, or two, it doesn't, there's nothing strange that somebody from crime intelligence continued to be part of the investigation even when the investigation was done by IPED because of this understanding that I have. Or you might say, it also looks strange to me. So that's what I would like to hear from you, whether what your own reaction is when you hear that this was the case.
No, Honorable Chairperson, I think, in a way, you have also answered yourself, that the operatives, as and when they appear here, From an operational point of view, they will be able to give you further detail, for an example. So it's possible that they will be able to say to you as chair of this commission and say, we had this much amount of information collected. But these were the dynamics and nitty-gritties that also involved that there were certain areas that could only be opened precisely because, you know, they knew us, so it was us who had this information for us to be able to access certain whatever. So, but that's the kind of operational detail that, in my view, as and when the correct people at an operational level are here, and I'm linking to the point that the chair correctly said, and said, look, you have not had everybody, sorry. Therefore, it's likely that as and when we draw in most of these individuals that were involved in this investigation and maybe collection at some point and so on, that matter would be clarified.
But what I would like you to help me with is whether, as somebody who was Minister of Police for a certain period, whether you regard it as normal for crime intelligence, one, to conduct an investigation as opposed to gathering information. I think you made that distinction earlier on. And two, to be part of an investigation that is conducted by IPED. Is there something that would happen in their normal, in the course of their work, as far as you know?
Look, I wouldn't know as far as I know, but I think this question that the Honorable Chair is posing is a relevant question. It's relevant in the sense that it really depends on what the issues were, I suppose. You know, but if you were to ask me at a general level, you are making an inquiry, for an example. I'm just making, this is now a general thing. You're making an inquiry about a certain matter, but who's outside of your function, I happen to be holding a particular information, okay? I think it would make sense that I would have to cooperate with you and say, I hand over this information to you to assist you in your inquiry or investigation that you're making. Now, it's then the question of operational detail of, do I continue to be involved with you for whatever the reasons are, because it really depends on the nature and the weight of that information, I suppose. And to what extent do I continue to assist you in your investigation? And my understanding is that if you look at the historical sort of reports around this issue, crime intelligence is identified as assisting in the investigation, not that they were conducting investigation. So the investigation was conducted by IPED. But for whatever the reasons were, maybe they were operational reasons, whether they were sound or not so sound, I think operatives in that regard would be able to shed some light.
But in terms of the scope of their work, you are not able to say whether this would normally fall within their scope of work.
No, I mean, in terms of the scope of their work, of course, they would not be conducting investigations, they would be collecting information.
Yes.
They would not be investigating police misconduct, for an example.
Yes. Okay, I think that answers my question.
Okay.
I just mentioned, for what it's worth, and you probably can't say anything about it, but it just adds to features that make the involvement of the crime intelligence features that make this investigation strange, or their interest in the matter strange. That according to Mr. Kuba, in his affidavit, one, Miss Mbeki, Kuki Mbeki, told him to keep the involvement of Mr. Mukangwe secret. Two, according to Mr. Kuba, Mr.
Keep the,
Sissoco-
I'm sorry, Chair,
Sorry.
I'm sorry to disturb you. Keep the
Yes.
involvement of Mr. Mukangwe. That's the part, there's a part that I could heard about Mukangwe, yes.
Yes, I'm sorry. I'm saying, according to Mr. Kuba's affidavit, one of the strange things for me is that according to him, Ms. Kokimbegi told or instructed Mr. Kuba to keep the involvement of Mr. Mukangwe secret in the investigation.
Oh, okay.
Yes, that's one. Two, Mr. Kuba says in his affidavit, Mr. Mukangwe asked him to use certain email addresses when sending him documents about this investigation. But what is strange is that he didn't want Mr. Kuba to send him those documents or emails to his official email address. He gave him a certain email address.
Okay.
It does not, I get the impression from what Kuba says in his affidavit that it might not even have been his personal email address. He insisted that they should not be sent to his official email address. So there are other features that are strange for me, but I'm saying, I'm mentioning these, you probably can't comment on them.
Oh, yeah, no, I hear you, Chair,
Yes.
but there's hardly
Yes.
anything that I can
You
really
can't,
say
yeah.
about that, yeah. No, thank you very much.
Thank you.
Thank you, Mr.
Hadi.
Chair. But there's a
sorry, Chair.
further concern.
I'm sorry, I think
Sorry,
Mr.
Chair,
Mukari has something.
before Mr. Hali puts the question, for purposes of arranging my day, I see that we're no longer sticking to the times that were spoken about yesterday. I had to arrange my day in such a manner that I accommodate the proceedings continue today on the basis of what was said. I moved my commitments to the afternoon, 2 o'clock and 4 o'clock. And so if I may be told again that we're going to go on so that I can be able to again then shift my commitments.
No, I'm terribly sorry, Mr. Mukari. Actually, about 11:30, I thought of raising the issue, but I think something happened and I forgot. I did say that we have got to finish within 2 hours, and in 7 minutes' time, it will be 2 hours, I think. But it's quite clear we are not done. I also still have got quite some questions. I think as far as today is concerned, everything has been going satisfactorily in terms of everybody has been dealing with matters the way I expected. So there's been cooperation from all sides. Let us talk about what should happen. I know that Mr. Ntlego wanted to get done, and that's why we have moved, and Mr. Mukari also wanted the
I
same.
think all I need to know, Chair, is how much more time so that I'm able to move my commitments.
Yes.
That's all what I need.
Yes, well, let's talk about that. Do we, Mr. Halley, what is your own sense? We have got to
Mr. Chair,
do justice in the end, but we must not take too long, but we must still do justice.
obviously, when I formulate an assessment of time, I do so with reference to the questions that I've got and a response which I think will be accurate according to this. Sometimes if the response is different, it might take me down a different pathway. But speaking generally, I would have thought that 2.5 hours, the assessment of 2.5 hours yesterday would have been a fair assessment. There's been a few disturbances today, not necessarily related to Mr. Ntlego himself, but there have been a few disturbances. The point I'm making simply is that I think I've still got 1, essentially about three broad issues that I still need to discuss. A lot of it is already dealt with in the affidavit, but I need to get clarity on exactly what has been said with reference to the affidavit.
Yes. Well,
So to answer your question, Mr. Chair, I would have imagined that if everything goes according to the way I formulated it in my head, it would take about an hour and a half at most.
I'm sorry, just repeat that.
What I'm saying is that my assessment, based on the questions that I would ask and the answers that I had anticipated getting, I would have assessed that it's around about an hour and a half. But sometimes there's an explanation that
And
accompanies the
sometimes the
answer.
chairperson also has questions.
I didn't say that, Mr. Chair.
No,
Actually, we must give-
I think I can say you are diplomatic.
Actually, when he says an hour and a half, then we must put 30 minutes of the chairperson.
No, that's true.
No, Chair, then that's all what I wanted, just an indication.
Well,
So then so that that's fine.
the reason why I'm taking longer to answer that question on your part is that I realize that this is quite an important thing, and it's quite obvious from Mr. Ntlego's statements over the past 2 days that also he regards this as very important, so it should be dealt with properly. I've been thinking about whether we shouldn't run away from the idea that we might not finish, so that when he comes back to cross-examine Mr. McBride, we can make space for him to finish first. So that's why I didn't want to immediately answer you. I know that he might have something to say, but Mr. Mukari, do you have something to say, even though he might have something different to say?
Yes, no, I'm saying that my question was only in relation of me then arranging my affairs then for today, not that I was saying that.
That we
so I
should
just want
not,
to know, because I mean, it would be unfair for me to sit here whilst I've arranged with people.
No,
So,
that's fine,
so all what I needed was, now that you've
How
given
long?
me the indication.
Yeah.
So during lunchtime, I'm able to then simply then rearrange
Yes.
my affairs. So I'm not saying that
Yeah,
we should not continue
not, yeah,
until we
okay.
finish. But I would prefer that we run and we finish with him.
Yeah.
So that when you come to cross-examine, we cross-examine the McBride.
Yes,
He's going to be
yes.
cross-examined by many people, then this may again then disturb.
Yeah.
And then he has to come from KZN all the time.
Yes. Mr. Ntlego,
So
you
if we
wanted-
can just proceed on that basis.
Yes, Mr. Ntlego, you wanted to say something, you raised your hand.
No. I do confirm this position,
Yes,
that in
yes.
fact we should finish.
Yeah,
But I would have said that perhaps to be on the safe side, we should finish at all costs,
yeah,
which
we
means that even if it would mean we sit here till 12 midnight,
yeah,
I would still prefer that we do that, and then we finish.
yeah.
And then we come back with a dedicated focus on cross-examining Mr. McBride. So that's just my suggestion.
Yeah.
Of course,
Yes.
I'm not a member of the commission.
Yeah.
I'm being subjected to it,
Yeah.
but it's
indicating
a
your
suggestion that
preference.
I'm making.
Yeah.
Yes.
No, that's fine. Well, I think let's continue and we'll talk about how long just now. Because the investigations continue, there can never be a guarantee that you can't be asked to come back if there is a reason, you know.
Yes,
so,
if there is.
But I think the idea is, if we can, let's see if we can try and finish. So I think shall we continue?
Thank you, Mr. Chair.
You talked about 1.5 hours
I spoke of 1.5 hours based on my assessment.
on your, yeah, but it could be.
In my own head.
Let's continue, and shall we say, I don't know if Mr. Noche is here, on the basis that we were going to finish before lunch, there was to be another witness. But I think that that can be sorted out during lunchtime. Let's continue, and at 1 o'clock, let's see whether we take the lunch break at 1 o'clock, maybe a shorter lunch break, or whether we take a full hour, and then maybe, if need be, we continue until maybe 3.
Thank you, Mr. Chair.
Let's see how would that affect your situation, Ms. Mokari? Is that fine?
Chair, all I needed was an indication, then I'll
indication,
move my things so that we can
Yes.
finish today, yeah.
Okay.
Yes.
Let's say at this stage, we are going to try and finish as early as we can, but at the same time, we want to do justice to the issues, and we are looking at not going beyond 3 o'clock if possible.
Thank you, Mr. Chair.
Okay.
Now, of course, there's an additional problem, and I want to explore this with you, Mr. Nhleko. If I understood the evidence correctly, based on the docket, there were at least the DPCI, which was the Hawks, may have been involved in the investigation sorry, let me rephrase that, may have been implicated in the investigation in respect of the rendition. So there were some Hawks officers that were part of the operation and as one of the different units. Another one was crime intelligence itself. Members of crime intelligence were also part of the investigation, sorry, part of the rendition, in the sense that they too had been assisting in the arresting of people. So the proposition I'm putting to you is that it seems to be problematic at least 3 levels. One level is that it seems that crime intelligence is in fact investigating crime intelligence. That's quite apart from the fact that crime intelligence shouldn't be involved in an IPRI investigation.
No, it sounds like you are making an observation. I mean, you are, I suppose, Mr. Hali, within your right to make such an observation. I also still to think that at an operational level, there will be probably clarity around these questions. The involvement of crime intelligence, DPCI, and whatever else and so on. I think people who investigated and other people who played a role in the investigation, should be in a position to clarify the commission around these particular matters.
And my question
But
is,
you are making an observation, and that observation is an observation, sir.
no, of course, but I want to, my observation, of course, is meaningless if there's no evidence to support it. I really want your comment on that. That's my observation, but I would like to know whether you would support that observation as the Minister of Police, that if crime intelligence or members of crime intelligence...
You may be able to say, I think it's a legitimate observation. You may say, I don't think it's well-founded because of A, B, C, D, or you may say, I'm not able to comment.
Look, yes, I may not be able to comment largely because, Chair, I wouldn't know the original reasons why, whether they got involved and to what extent they got involved. So that's why I will not be able to, to comment. But if you were to ask me, Mr. Hali, and I'm not suggesting that he should ask me that question. In fact, you are prohibited, Mr. Hali, to ask that question. But the point really being here, whether as a matter of principle, is it correct for an institution to investigate itself? Then I can tell you that it is not correct. So, and conceptually, that's a different matter altogether as opposed to, yes. So,
Yeah. Well, it's the same point you made yesterday, that, well, maybe not the same, but it's related, namely that it wouldn't be right for IPED to report to the National Commissioner because the National Commissioner
Yes.
falls within their jurisdiction of investigation.
Yeah. Is a standing implicated institution.
Thank you, sir. Now, the report, or rather the appointment of worksmans, as understood it from the terms of reference, and of course, please correct me if I'm wrong, but my understanding was that worksmans was supposed to conduct interviews. Is that correct?
Yes, I'm listening. I'm listening, sir.
Well, I'm asking if it's correct. Was it your understanding that you wanted worksmen to conduct interviews?
Look, again, that's operational detail. Vexman were given a set of terms of reference. Now, operationally, what it means is that as and when they conducted this work, they would then design their work. Okay, I would not design work for them, for an example.
So in other
So
words,
if they-
was your position that they should conduct an investigation? These are the terms of reference. How they went about it was up to them.
Exactly, it's because that's at an operational level. So I suppose, for an example, if you were to say to me, I must investigate a matter which, whatever, I would take your terms of reference and translate them into a work plan and say, this is how I want to go about this, and what kind of a definitive kind of approach, an established kind of standards, for an example, that I would want to follow as an investigator. But I would not then design work for you, in a sense, as an entity that would be investigating. Yes. And maybe just to complete that point, Chair, I'm sorry, Mr. Halley, the terms of reference, who and under which circumstances was the original report altered, and or how the second report came about with both reports signed by the same person, i.e. Mr. Kuba, whether any misconduct or offense has been committed, and if so, by whom. Thirdly, whether there is a prima facie evidence of misconduct and criminal liability by Lieutenant General Dramat, Major General Sbia, and any other officers mentioned in the original report. Fourthly, the circumstances under which report and the docket handed in the NPA, and what happened to the docket whilst in the NPA possession. Lastly, any other matter that might come to your attention during the investigation which is relevant to your conclusions and findings. That's how the terms of reference were framed. But then in the report by Vexman, they then went into the detail in terms of how they went about their investigation. They referred to interviews, recordings, statements, and whatever, and so on, that they collected and so forth. But that was not prescribed by me. I gave them the terms of reference. They then designed their work. Thanks, Chair.
Thank you, Mr.
And
Chair.
thanks, Mr. Halley.
So, as part of the terms of reference, you say in paragraph 6, Mr. Chair, for your benefit, the relevant document is in bundle LEA2. And it's an
I
annexure.
see that my bundles have still not been written.
My sincere apologies, Mr. Chair.
This one is bundle LEA.
LEA 2,
That's the one that has got exhibit Y8B.
that's correct, Mr. Chair.
Has somebody given the witness the right bundle?
No, I'm fine. I think I'll follow you. No, I'm saying I'll follow you, but I think I saw it here. It's all right. The bundle, yeah.
So, Mr. Chair, to be specific,
It's just that I no longer have sufficient space here, so
Oh, is that so?
that's why I'm going to use my ear.
Oh, okay.
Yes, so
Well,
it's all right.
you can keep it away if you think you can follow, but
Yes,
as and when you think you need it, indicate.
Yes, I would definitely
okay.
do
No,
that,
that's
yeah.
all right.
So thanks.
That's all right.
Thank you, Mr. Chair. The relevant page is at page 638 of that bundle.
What's the page number?
638, Mr. Chair.
638.
That is correct.
Yes.
And in paragraph 6, you say to, as part of your terms of reference, you say to Worksmans that in your investigation, you will interview the relevant witnesses at your own discretion and have access to all relevant documentation, including the 2 reports, the docket, and witness statements made so far. So in short, they were required to interview relevant witnesses at their discretion in order to complete the task that you had placed before them.
Right.
And the task that you had placed before them and to which you wanted an answer was, in the second instance, to determine whether any misconduct or offense had been committed, and if so, by whom. Now, when you talk about an offense, you're referring specifically to a criminal offense.
No, Mr. Hanley, offenses, they're also committed at the workplace level. It's an offense not to follow or violate policy, for instance, a workplace policy. So it's not only in relation to
So
criminal.
you meant both a criminal offense and a disciplinary offense?
No, my focus was the question of
A disciplinary.
disciplinary, what the act of misconduct, what
Yeah.
does it then do
Okay.
to the image of the institution?
Okay.
Yes.
And then in paragraph 3, or subparagraph 5.3 rather, you ask whether there is a prima facie evidence of misconduct and criminal liability by Lieutenant General Dramat, Major General Sabia, and any other officers mentioned in the original report. See that?
Yes, I see. Yeah, I hear that, sir.
So insofar as they were given a mandate to interview relevant witnesses at their discretion, they had to determine whether a prima facie evidence of misconduct, certainly, but also criminal liability existed. And to that extent, they were entitled to interview witnesses. Correct?
That's correct.
Now, to that extent, with respect, Mr. Tleko, they would be conducting a criminal investigation, would they not?
No, I don't think so. I don't think so. You had the Honorable Chair, Mr. Halley. You had a report, January that is, that said these 2 human individuals are implicated in the commission of crime. And then you have another report, the 18th of March, which then exonerated them and pulls them out of this. Now, So we are then investigating, first and foremost, why you have this disjuncture between the two. But also secondly, that you also need to review available sort of reports, documentation, and whatever else. Because it's possible that the second report may be saying, no, we are not liable for a criminal prosecution. I'm just making an example, as recommended. But then, again, Chair, the issue that interestingly you raised yesterday, if you look into the documents that produce the report, and that is the docket, actually, there are statements and reports that implicate these individuals in wrongdoing, right? So that necessarily is not understood as, you know, a legal firm that then is conducting a criminal investigation. So that's a distinction, Mr. Hale.
No, I understand you to be saying that there was information in the dockets, there were statements that were there, and they were certainly entitled to analyze those statements. That's part of their mandate. My earlier question to you, to which I thought I had an affirmative answer, was as far as that is concerned, i.e. clause 5.3, were they also entitled to interview witnesses? I understood your response to be yes. Did I misunderstand you?
I think this point has been canvassed and subsequently sort of responded to.
I'm sorry, I didn't hear that question. What was the question?
So the question, based on the earlier statement, clause 5.3 says, amongst the issues that need to be investigated and to be reported upon as part of the terms of reference was whether there is a prima facie evidence of misconduct and criminal liability by Lieutenant General Dramat, Major General Sabia, and any other officers mentioned in the original report. Part of their terms of reference includes a paragraph 6. It says, in your investigation, you will interview the relevant witnesses at your own discretion and have access to all relevant documentation, including the 2 reports, the docket, and witness statements made so far. So the question that I'd asked Mr. Nhleko earlier was whether in doing so, they would be entitled to actually interview witnesses in relation to clause 5.3. I understood the answer to that to be yes. In other words,
Yeah,
in
no.
respect of
Yeah, because he said that how they went about the investigation was their business. You draw attention to paragraph 6, which said they will interview relevant witnesses at their own discretion, which seems to say the same thing, if I'm not mistaken. So it seems to me that he contemplated, and he can speak for himself, my understanding is that he contemplated that if they want to interview witnesses, it was up to them.
Chair,
Yeah.
just to clarify this point, Eddie Father, really. You know, it was critical and important that in the exercise of this work that I conducted and asked Waxman to do, the element of fairness and being just had to be maintained. It had to be there all the time. In other words, it would be unheard of that you're conducting some inquiry of sorts, but eventually you arrive at a conclusion about somebody whom we have not spoken to and find and establish his or her side of the story, for an example. You know, I don't know what they call those kinds of investigations really, but it's a biased form of an approach. And therefore, in the framing of the terms of reference, it's vital, the question of, yes, This gentleman seated across me here is said to be implicated in this and that, and that, but let me hear him out, and so on. By so doing, you are able to come out with a balanced and an objective product, which is then also is going to assist me as an employer at the time, of course, to be able to act accordingly in following the legal prescripts that govern our country and institutions. Yeah. So I think it should be understood in that sort of context also why that term of reference was included.
But it may be important to understand what the answer you give now does to the earlier answer. The earlier answer having been, I gave them a mandate. How they went about their investigation was their business, okay? But what you have said now seems to emphasize the question of interviewing witnesses on the basis that you say, but it would have been unheard of for them to reach their conclusion without having interviewed persons who may be implicated.
Yes.
So I think that you are saying those two things. Now, of course, you might not say anything to them in your brief to them or mandate to them about interviewing witnesses when your expectation is that they know what they are doing and they will make sure that they conduct the investigation in a manner that meets basic elementary rules of fairness. So you might then say, I'm not going to mention that because it's to be assumed that they will interview them, but you may have a situation where an interview is not necessary, but they send somebody who is implicated an invitation to say, give us your side of the story in writing on this issue and this issue and this issue. So in other words, there might be no interview, but still the person has been given a chance to put their version. So I'm just mentioning because the latest seemed to emphasize that your expectation was that there would be interviews.
I'm also, on the one hand, explaining the framework and the outlook, character-wise, of the terms of reference. You see, let's take an example, the first term of reference. It says who and under what circumstances was the original report altered. Now, you are not going to work on the basis of a hearsay to answer this question. All right? It's the same thing, and I think yesterday I made an example about an allegation that says you have stolen a goat. The starting point is that, yes, you have that allegation, but we want me to know, to establish the facts, whether indeed it did happen. So I would come to you and say to you, Ngobese says you stole his goat. Do you know anything about that? Is it true? I'm just making an example. So
what do you say about this allegation?
Exactly, you know, that sort of thing. So, and that approach, I'm arguing further and say that approach satisfies the rules of fairness and being just.
Yeah.
Yeah. That's all that I say. Thanks.
Thank you, Mr. Chair. I understood from your testimony yesterday that when Worksmans phoned you and said, or contacted you in some way and said that they receive no cooperation, you then telephoned Mr. Kuba and said to him you'd like him to cooperate, or you told him to cooperate. Now, my understanding was, and perhaps I'm wrong, my understanding was that you were directing him or instructing him to cooperate. You were not saying to him, out of fairness, I would like to afford you the opportunity to cooperate.
Yeah, but Mr. Hali, how do you come to that conclusion? Maybe just for the benefit of this exercise, how do you come to the conclusion that your understanding was I was instructing him?
Based on
Maybe start there.
Well, maybe let's put it this way. If you say, I was not instructing him, then you have answered the question. If he has further issues, he has an issue with your answer, he will follow up. If not, it falls away.
Now, Honorable Chair, I understand
Yes.
that also there's a cultural conflict here in a
Yes.
sense.
Yes.
You know, that's a court approach.
Yes,
Okay.
yes. Yes,
But for me, understanding that this is an inquiry,
yeah,
you know, it also becomes useful to understand an informing state of mind behind a particular question and or conclusion. I'm just making an example.
no, I
You know,
understand
because I
that.
don't want to understand Mr. Hali as saying that this is what I said.
Yeah.
You know, so that's
May-
the
may-
thing. That's
may-
why I
Maybe
do
let's
this.
do it this way. Mr. Hali, put the basis for your suggestion to him to say, this is your suggestion that this was instruction because based on this, and then he can respond.
Thank you, Mr. Chair. When I listened to your testimony yesterday, I understood you had telephoned him in order to instruct him, based on what you had testified, instruct him that he was to cooperate. I might be wrong about that. My recollection may be hazy, but that was certainly my understanding.
You are correct insofar as, yes, I did telephone him. You're correct. You are incorrect insofar as you understood that to mean an instruction. I requested him to cooperate. And that's basically it. Thank you, Chair. And may I also state that the level of mortuariness has improved a little bit. No, it's a little bit better. As to whether it's comfortable, as to the same extent as the chair where he's seated, so that's a different matter altogether.
Well, I can tell you that it's only in my legs that I feel some some warmth. On my upper body,
Okay.
I feel quite cold as well.
Right.
Yes, okay, all right, thank you. Yes, Mr. Hali.
Thank you, Mr. Chair.
May I ask this while Mr. Hali is looking for something? In the terms of reference, was there any reason why under 5.3, you don't have to look, I will tell you what it says, why it was necessary to specify the names of Lieutenant General Dramat and Major General Sibia, where you say workmen had to determine whether or investigate whether there is prima facie evidence of misconduct and criminal liability by Lieutenant General Dramat, Major General Sibia, and any other officers mentioned in the original report, as opposed to simply saying that to investigate whether there is prima facie evidence of misconduct and criminal liability by any officers mentioned in the report. Was there a particular reason why the two were specifically mentioned by name?
You know, I suppose it's a explicitity in a sense, because the bone of contention was, the basis of contention here was the question of the two reports and subsequently the recommendations. One set of recommendations with explicitly the names of the individuals that the chair has referred to. The other set of recommendation, this other end of the second, so-called second report, those names having been taken out and so on. So I suppose that's the reason why.
It was the reason, yeah.
Yes, that was the reason why to.
Yes,
Yes.
yes. I don't know if Mr. Halley covered this, but let me ask. Bearing in mind your evidence that the area where you were to make decisions related to disciplinary matters and not to crime, the NPA would decide matters of crime. Why was it not enough in 5.3 in the terms of reference to say they must investigate whether there was prima facie evidence of misconduct? Because isn't it anything that's a crime would fall under misconduct as well, or would it not?
No, but the point, Chair, is there's no way you will be responsible for a policing portfolio and not be concerned with a situation where your officers are implicated in crime. There's absolutely no way. I think you'll be totally sort of remiss in your responsibility not to be concerned about that. Much as you are not the prosecuting authority, for an example. But, you know, from just your both constitutional and institutional duty, you should be concerned about these, you know. And I think as a matter of fact, I think if remember, it's their workplace, all right? They have got to uphold the law at all material times, follow policy to the letter, and so forth. They have to be the face of the institution, but also they have to be the face of our constitution and the ultimate outlook of our society, okay? Now, but then you have this allegation that this officer is involved in crime, in the commission of crime, right? So, indeed, that does something to the reputation of the institution, okay? And of course, you will not necessarily prosecute this employee on the basis that you committed ABC, which falls under criminal activity.
But you want to know.
But you want to know, and if that has happened, it's a disrepute to the image of the institution. Yes.
Okay.
Thanks.
Mr. Halley?
Thank you, Mr. Chair. Could I ask you to turn with me to bundle LEA 7?
Yeah, go ahead, sir.
Okay, he has got it.
Thank you, Mr. Chair. It's
I'm
it's
sorry,
ex-
what did you say?
it's bundle one, sorry, LEA 7, Mr. Chair.
Is it the one marked Y8H?
It is. Sorry, Y8G, pardon me, Mr. Chair. It's Y8G.
LEA
LEA 7, Mr. Chair.
bundle LEA 7. Okay.
That is correct. And the specific exhibit is Y8U. It's at page 3,342, Mr. Chair.
3,000,
342.
3342.
That is correct, Mr. Chair.
Yes.
This is an affidavit by Mr. Nhleko. Can I ask you, Mr. Nhleko, if you would turn with me to page 3347 of that document?
What page?
3347, Mr. Chair.
Okay. Okay, just to place on record, that's an affidavit by the witness. Dealing with allegations by Mr. Kuba, it starts at 3342. You say we must go to 3347.
That is correct, Mr. Chair.
Yes, continue.
The signature on page 3347, sir, is that your signature?
I seem to have I do have LEA 7, but I'm not following the page. What's,
Right, in the top right-hand corner, page
Right.
3347, 3,347.
I was
It's
actually,
somewhere right towards the end, if you have got the right
yeah,
one.
I'll get it, 3047. In fact, I think I was there and I saw something else.
My
The very
concern is
last
that you,
page, or the very last document.
my concern is that you are at the beginning of the bundle, whereas this page is one of the last ones in the bundle.
3047.
3347, 3,347.
Actually referring to is,
okay,
are you referring to the affidavit of Friday?
That's right.
Yes, so that's the Friday affidavit.
3347.
3347.
Where did I get the zero from? I thought it was 3047.
It must be Mr. Halley's pronunciation. Mr. Halley.
Probably my level of educatedness, Chair.
3347.
33,
Yeah.
yeah, 3347, I've got it.
3347, yeah, okay.
No, thanks and apologies, Mr. Ali, not to get this thing right.
Is that your signature, sir?
Yes, it is my signature, sir.
And this is an affidavit that you deposed to on the 24th of July of 2020, is that correct?
That's very correct, sir.
I'd like you to turn with me, if you will, to, to page 3345, paragraph 7.
Yes,
You say, I confirm calling Mr. Kuba. This was after I had been made aware by Worksmans that he was not cooperating with them. It is clear from the above exchange between the chairperson and Mr. Kuba that the purpose of my call to him was to entrust him to cooperate with Worksmans in their investigation, nothing more and nothing less. So you say that the purpose of the call was to instruct him to cooperate. Is that correct?
it is clear from the above exchange between the chairperson. Who's the chairperson?
The chairperson before you today.
And that paragraph
But
comes
but
after,
that
that paragraph of your affidavit comes after a quotation of Mr. Kuba's evidence from the transcript, I think.
No, but where does it say that I instructed him? Because it's a reference to an exchange between the chairperson of the commission and Mr. Kuba.
Look at the second line of paragraph 7, second sentence. It says, it is clear from the above exchange between the chairperson and Mr. Kuba that the purpose of my call to him was to instruct him to cooperate with workmen's in their investigation, nothing more and nothing less. Says, I find it rather curious that despite Mr. Kuba stating categorically that I did not propose that I meet with him in Cape Town, but that it was my PA that proposed, the chairperson continued to speculate that I wanted Mr. Kuba to come to Cape Town to meet with me. Well, you have not been asked about the second, the last sentence. You have been asked about the one before, but I was reading it just in case there is something there. So I'm not going to say anything about it.
Yeah. No, I don't know if my request was understood as an instruction. Maybe it was. I don't know. But the point is, I asked him to cooperate with the investigation.
But let's get back to page 638.
Well, maybe before you go elsewhere, Mr. Halley, but Mr. Trego, it's not, this sentence doesn't say Mr. Kuba understood what you said to him as an instruction. It's you speaking, saying the purpose, saying it is clear from the above exchange that is between me and Mr. Kuba that the purpose of your call to him was to instruct him to cooperate with workmen's. So in other words, what you just said after we looked at the sentence suggested, you were suggesting that if what you said was understood as an instruction, so I'm saying, but you are the one speaking in this sentence, saying it is clear from the exchange between myself and Kuba that the purpose of your call was to instruct him, and you continue to say nothing more, nothing less. So the sentence doesn't say Kuba said he understood that I was instructing him, but actually he is mistaken. I was not instructing him. It's you saying the exchange reveals that the purpose of my call was to instruct him, and nothing more, nothing less.
No, that's fine. I note that
You
point.
know,
Yeah, I note
okay,
that
all right.
point, yes.
Okay. Mr. Hadi?
Thank you, Mr. Chair. And if we could go back to the terms of reference, which appears in bundle LEA 2, and to page 638 of that bundle.
What page should we go to?
638, Mr. Chair.
600?
638.
638. Yes.
Thank you, Mr. Chair. These are the terms of reference, and I want to just pick up on the distinction that you made with reference to offense. You said you acknowledge that an offense might refer to a criminal offense, but you said your focus was really on misconduct for purposes of disciplinary processes. Is that correct?
Yes, that's correct, sir.
Now, I'm just trying to understand, if you can read that sentence to me again, paragraph 5.2. And then reconsider your answer.
Which says whether there is a prima facie evidence of misconduct.
5.2,
What does it say? How does it start? I'm using it.
whether any
My
misconduct.
Yeah. Whether any misconduct or offense has been committed, and if so, by whom?
So what you are suggesting is that that sentence, as you understood it or what you had intended to convey, was whether any misconduct or misconduct has been committed, and if so, by whom? Is that what you're saying?
It says whether any misconduct or offense has been committed, and if so, by whom?
So clearly you're drawing a distinction between misconduct, which is of a disciplinary nature, as between an employer and an employee, and an offense, which is of a criminal nature, which may involve another person, or but is a matter for the law enforcement agencies. Would that be fair to say?
No, it's not fair. Because you could also use the term offense as a matter of an emphasis.
Sorry, I don't follow that answer.
I'm saying, Chair, you could use the term offense as a matter of offenses, misconduct and or offense. You know, but it does not suggest that, because once you want to suggest that the usage of the term offense applies only to criminal investigations, I think that's incorrect.
I'll tell you what I expected your answer to be. Based on what you said with regard to 5.3, where you have a reference to misconduct and criminal liability, and based on what you said, why you would nevertheless be interested to know whether a member of the police service had committed a crime. Based on that, I would imagine that when in 5.2 you talk about misconduct and offense, it would fit within that understanding. You want to know if there is misconduct committed by a member of the police service, misconduct which is not a crime, but you are also interested to know if there is a criminal offense that has been committed by a member of the police service. In other words, you are not confining yourself to disciplinary misconduct only. You are also interested in knowing whether a member of the police service has committed a criminal offense. So to me, it seems that that's what I would expect you to say, given the answer you gave earlier on.
Yes. Look, I accept that, Chair. That's also one way of looking at it. But you'd also, earlier on, I made a point, and I said, every workplace is governed by a set of policies and rules and regulations. But also an offense can be committed at a workplace level. For instance, being drunk on duty, it's an offense. Whether it could be criminal or purely an issue of misconduct. So from a broad sort of general understanding point of view, I think also the usage and application of the term offense should not be construed necessarily to mean criminal investigation. You know, so much as the Chair is correct in respect of this particular specific matter, relating to the mere fact that there was a criminal investigation conducted, and one report said this and the other report said that, and so on. So I accept that, but I'm also broadening it out and say, but the usage of the term offense does not necessarily mean that if anybody says, yeah, but it's an offense for you to do this, then that would mean you've committed a crime or something.
I don't think we should spend too much time on it, but I think the reason was simply because when you say misconduct,
Yeah.
that would cover a certain category. When you
Right.
say offense, it might mean whatever is not covered under misconduct might fall under offense, yeah.
Okay.
Thank you, Mr.
No,
Chair.
thanks, Chair.
And of course, what we must bear in mind is that when this matter had been handed over to Worksmans pursuant to these terms of reference that you have outlined here, General Ramat had already been suspended some 2.5 months before that. Is that correct?
Yes, I hear you.
And here you are asking them to investigate the very issue that he already taken a decision on.
And what was my decision, Mr. Harley?
That he should be suspended. Because in your view,
Let me come into this thing, because I think, and sometimes I do find the Honorable Chair strange that even lawyers, they miss the point when it comes to this issue of suspension.
Yeah,
In fact, the correct term in the public service context is precautionary suspension. And all it does really, it says, as so-and-so, there are these allegations that are leveled against you. And we, in other words, as the employer, would like to have an opportunity to investigate these matters further. But in so doing, there should not be an element of interference and or perceived interference. You know, so we are also addressing the issue of perception. So which means there is no decision against you in relation to the alleged violation. It's just for the employer to establish facts around this and then take it on from there, whether or not and whatever. But for some strange reason, many people, including legal practitioners, have begun to understand suspension as a punitive measure when it is not. In fact, suspension also deals with the question of even protecting the same employee. So I'll give you an example. I'm working for the commission, which I truly hope never ever happens. But I'm making an example, Chair, that I work for this commission. But I think there's a Reverend Stemmeler.
Reverend Stemmeler.
Yes. Is a co-worker with me. So, but the allegation, it involves our unit, whatever our unit is within the commission, together with Reverend Stemmeler. Now, and the allegations, it's me who are facing them. If I'm not removed from the workplace for investigation to take place, it is likely that when I come in one day and I have a sour face, you know, and I look at Reverend Stemmeler could easily turn around and say, hey, the manner in which this gentleman looked at me, I can realize that he's really up in arms against me because he's being investigated and so forth. So it's also about insulating the very same employee not to be subjected to unnecessary negative sort of perceptions, even at a workplace level. But similarly, you also have to protect the institutional process and information as well, amongst other things, so that there's no pollution that takes place there and so on. So that's how it has got to be understood. So I'm raising this point because the manner in which Mr. Harley is raising this issue embraces this negative concept or definition of this concept of suspension, which seem to have taken root out there in society, that if you suspend somebody, it's because that person is guilty of anything. It's not.
Mr. Halley?
Thank you, Mr. Chair. If I can move on.
Well, maybe before you move on, let me put this to you, Mr. Nhleko. My understanding is that most, if not all, suspensions, maybe I should stay with most and not go to all. Most suspensions, whether you talk about the private sector or the public sector, suspensions of employees are not based on any finding that has already been made that the employee is guilty. They are effected to allow some form of investigation to take place before a decision is made whether the employee should be charged with misconduct or not.
Yes.
Sometimes they happen at a time when the investigation has taken place, but the hearing, disciplinary hearing, and a decision to charge the employee has been taken, but there's going to be some time before the hearing actually starts and the employee is suspended. The decision whether the employee is guilty or not would be taken by the chairperson of the disciplinary inquiry in due course. So, but nevertheless, there is a general, I think, understanding within the public sector and maybe the private sector, I'm not sure, that before you effect even that suspension, you as the employer would need to be of the prima facie view that there may be something that the employee is guilty of. Because otherwise, if you think there is no basis for this allegation, you wouldn't go that far. That's my understanding of the situation.
No, but if we had to do that, Chair, whilst I agree largely with what we have just said,
Yeah.
if you were to assume guilt before investigation, then you're being unfair.
Well-
So that's why I'm saying in the public service generally, at least wherever I've worked, it's important to emphasize precautionary suspension, because the emphasis on precautionary, all it does is it then says, look, we want to have an opportunity to explore this matter further and so on. And we don't want you to be perceived negatively internally within the institution, nor do we want also to experience as an institution, for instance, a situation where there is interference with the information that we require for purposes of investigation. I'm also aware, because I think the chair has also, broadened this thing and alluded to it. I'm aware also that in other institutions, there is a sentence of suspending somebody without pay for a particular duration,
Which is separate, which is a different
Yes,
thing.
which is separate, but that's after a disciplinary
hearing,
process would have, ensured and so on,
Yeah. No, and the point you make is that the suspensions you talk about in the public sector and the suspension we're talking about here in regard to General Dramat was a precautionary. And
yes.
not a punitive one after a hearing.
Yes,
Okay.
yes, Chair, thanks.
Thank you, Mr. Chair. Now,
Oh, I see we are at 1 o'clock. Is everybody amenable that we take a shorter lunch break, like 30 minutes?
thank you, Mr. Chair.
Would that be fine? Mr. Nhleko, would that be fine?
Oh, no, I'm more
You'll
than
be
good.
fine.
Yeah, it's
There are
like
two
a Sunday morning.
options. Either we move now up to 1:30 and then we take the lunch break, or we take the lunch break now and come back at 1:30. Is there any particular preference?
Perhaps we should take the lunch break now, Mr. Chair. I would imagine that it would be suitable for Mr. Mukari because I suspect we're going to go into his
Yes.
first appointment.
Okay, let's take the lunch break now then, and then we'll resume at 1:30. Okay, we adjourn.
Thank you.
particularly seems to be, it's marked as A1 in the docket, which from the instructions that I've received means that it's the very first statement in the docket. It's the statement usually of the complainant. That's the statement that gives rise to the charge sheet, or rather to the docket being opened.
Oh.
Now,
No, I hear you, and I'm following, sir.
Now, he says in paragraph 3 of his statement, he says, I've been duly mandated to depose to, well, he actually says dispose, but I imagine he says depose, he intended to say depose to this affidavit, by the acting national head of the DPCI, General Bernie Ntlameza, in my capacity as the office manager in the office of the national head DPCI. My duties entail, among other functions, dealing with the correspondence that needs the attention of the national head or has been dealt with by the national head DPCI. During the performance of my duties, I have on the 8th of May 2015 received correspondence from the Ministry of Police as signed by the Honorable Minister of Police, Mr. N.P.T. Nhleko, to the effect of submission of the report compiled by the Worksman's IPID Investigation Commission into Zimbabwean renditions. The report therefore elucidates some inconsistencies relating to 2 reports associated to a single IPID investigation on the issue of Zimbabwean nationals that were subjected to rendition, thus giving rise to an investigation of perjury, corruption, and defeat in the ends of justice by either the IPID deponents that were interviewed, compilers of first and second IPID reports. Now, are you familiar with the background leading up to this docket being opened?
No, I'm not. There's something that you read off there which I find strange. I mean, I wouldn't write as Minister of Police to somebody that I don't know, and somebody who's not the duly delegated person of the institution in question. So I wouldn't do that. So the person who deposed that affidavit, you said it's a Mr. or Miss what? Why?
Why?
Yeah, I wouldn't know that person.
Well, the person is saying,
So the person says I wrote to him or her, isn't it?
he says, during the performance of my duties, I have on the 8th of May, 2015, received correspondence from the Ministry of Police as signed by the Honorable Minister of Police, Mr. N.P.T. Nhleko, to the effect of submission of the report compiled by the Worksman's IPID Investigation Commission into Zimbabwean renditions.
There's something wrong with this formulation. Because there's a presupposition that I must have written to this individual.
Well, certainly,
Unless
what
this
the
person
individual
says-
suggests is that there is correspondence that came from you, whether it was directed to him or to somebody else, but he refers to correspondence from
Right.
you. But I'm not sure if it's clear whether the correspondence was directed to him or to somebody else, but he refers to some correspondence from you.
Yeah, unless it's somebody who introduces himself or herself, let's say as a registry clerk of something, somebody who receives correspondence and says, this is what I've received.
Well,
and
he occupies, it doesn't occupy, I think is he a lieutenant colonel?
If, Mr. Chair, if you would consider the
He's a
last
lieutenant
page.
colonel in the South African Police stationed at DPCI investigation offices in Silverton, Pretoria at that time.
Yeah. I don't know, I think it's something that would have to
Would
be.
you like to see the particular
No,
correspondence?
it actually doesn't matter.
Yeah, okay.
It's just that I think it's something that has got to, that requires further clarification at a later
Yeah.
point, because There's no way that I would write to somebody who's not the head of the institution.
Well,
I don't think
it
it's
may
like
be that you wrote to the head of the DPCI, but, and that correspondence was in the file that was given to this person for purposes of
So
preparing the
supposedly
affidavit.
by the head of DPCI.
Yes.
Okay.
Yeah, that is possible. I don't know whether Mr. Halley, you would think
Yes, I
that as
can
well.
be of assistance in that respect. If we could turn to page 3209, which is 2 pages before that.
Three 3209, yes.
Thank you, Mr. Chair. This is the letter that he's referring to, which is a letter dated the 8th of May 2015, which has your name at the bottom and is addressed to the acting head of the DPCI, General Ntlameza. And it reads, as the Minister of Police, I commissioned an investigation into the existence of the so-called 2 IPID investigation reports on renditions of Zimbabwean nationals. Such an investigation was concluded by Worksman's attorney on the 24th of April of 2015. This report is therefore referred to you for your consideration as it implicates some officials of the DPCI.
Okay.
That's the document.
Okay.
So
Yeah, I seem to
that
be.
makes sense.
Yeah, now I seem to be having at least some sense, an administrative sense of
Yeah.
perhaps what might have happened. Yeah.
Yeah, okay.
It's just that earlier on, Chair, it sounded like I must have written to
Yeah.
this Mr. Y or Miss Y. You know, and that was my confusion then, but I'm clarified. Thanks.
Well, what I was trying to ascertain is this was written to General Ntlameza because it concerned the officers under his command or people within his area under the DPCI, correct?
Yeah, correct.
It says that it implicates some officials of the DPCI. Specifically, it seems to be referring to, amongst others, General Ramat, General Sabia, correct?
Yeah, I'll take your formulation, yeah, amongst others.
I think there may also be a certain Captain Maluleka,
All right.
but those would be the 3 people from the DPCI who had been implicated in the Worksman's report.
Just 1 second, Mr. Halley. We did say we aim to try and finish at 3, or I did say we would try and finish at 3. Mr. Mukari had indicated yesterday that his re-examination should not be longer than 30 minutes. May I just find out whether that's still the position? He agrees. So it seems that you may have to aim to finish not later than 2:30.
Thank you, Mr. Chair.
Yeah, okay.
Now, what I'm trying to understand is how the people were implicated over here, and the purpose of the report related, of course, to the DPCI. It was given to them for their purposes.
Right.
And if you're not in a position to assist us, of course, by all means say so, but I'm trying to understand how we went from that to a criminal investigation that is opened against IPID officials. If you can be of assistance.
No, I think, Mr. Halley, I would not be able to assist you there. Yeah, I wouldn't.
Can I take you back while Mr. Halley is looking at something
Right.
to the decisions that you may have made with regard to or arising from the workman's report. Did did you make any decision of a disciplinary nature arising out of that report? And if so, in regard to whom? Like deciding to suspend, or that somebody must face a disciplinary hearing, must face disciplinary charges? Did you make any decision, any decisions like that arising based on that report?
Amongst others, I think it was certainly the suspension of Mr. McBride, arising
Of Mr. McBride?
of Mr. McBride,
Yes,
yes, arising out of that
Yes.
very same report.
Yes.
And of course, I think the relevant levels of authority then dealt with others. But at my level,
Yes,
it was the
yes.
question of
Yes.
Mr. McBride, I think,
Yes.
out of that report.
So in terms of any decision to suspend anybody arising out of that report, the only decision to suspend somebody that you took based on that report
Right,
was to suspend Mr. McBride.
right.
He was the only one in terms of the decision to suspend by yourself, not by somebody else.
No, he was suspended by myself, yes.
But yeah, okay. Mr. Kuba and Mrs. Sissoko would have been suspended by somebody else.
By somebody else, yes.
Yes, yeah. And in terms of whether any criminal investigation should be pursued, did you make any decision? Now, I accept that you are not the prosecutors, you are not in the NP, you are not in the NPA, but did you make any decision along the lines that the criminal justice system must, here is the report, they must make whatever decision they might wish to make?
Look, the report, Chair, has referred to different sort of arms within the police service. They also needed to read it, analyze it on the basis of their area of function.
Yes.
And then decide what it is that needed to happen. And I'm happy that the Chair qualifies this point that, you know, of course, I've got nothing to do with the NPA.
Yeah.
But also the NPA itself will not, on the basis of merely a report out there in public, then decide, no, we're prosecuting.
Yeah,
So
make their own investigation.
yes. So the arms of investigation, such as the police, whichever level it would be, would then be involved to look
Yes.
into that, and then
Yes.
look at how they work with the NPA
Yes.
in the construction of charges, if any.
Yes.
You know.
Let's talk about your decision to suspend Mr. McBride. Mr. McBride was not a signatory to the first report. Is that right? He was not a signatory to the first report.
Right.
Indeed, the first report had been given to the NPA before he joined IPID.
Right.
Yeah. Now, what was your understanding of what you thought he had done wrong, even if that was not a final determination, just prima facie, that really needed to be investigated, given that he signed the second report only and had not been there, he had not expressed or associated himself in any way with any views or analysis that may have been part of the first report on 22 January, because he was not part of IPID at that time. So up to a certain point, I do have some understanding of concern in relation to Mr. Kuba, who had signed the first report which said one thing and signed the second report which said something contradictory. But I'm not sure that I understand in regard to Mr. Sissogo and Mr. McBride, who only signed one report, namely the final report. So you being the person who made the decision to suspend Mr. McBride, I would like you to assist me to understand in your own mind, what did you see as prima facie wrong as far as he was concerned?
Honorable Chair, two things. The first one is that the contention here is not about signing. Okay, it's not about signing. And of course, you know, it's a different set of a debate in terms of regulations and applicable laws and whatever. So that's a different thing. But you know, what we seem to be forgetting is that we're all governed by principles of accountability. For an example, if I were to follow the analogy by the chair, it would also apply to me to then say, what do I have to do with the generation of a report by the Civilian Secretariat for Police, which was done in 2012, because I was not there. I only became minister in 2014. So which would mean any other work done before I came in, it's what I don't inherit. You know, I don't identify with it. In fact, I don't even want it. Government can't work like that. So
No, I don't think it's the same thing. Maybe
Okay.
let me take you one step further. What do you say to the proposition that says,
yes,
as far as Mr. McBride was concerned, he had regard to whatever he had regard to and came to the conclusion that the report that comes to you that is associated with him must contain an analysis that he was happy with and the recommendations that he felt he could justify. If the earlier report had a recommendation that he felt he could not be justified, or had an analysis that he felt could not justify, he may have said, well, this one that will have my signature must contain what I can also stand for, what I can justify. Now, what's wrong with that?
I'll tell you what's wrong with that.
Yes.
Chair. Firstly, it takes us back to this issue of you have a report that is in there, you don't nullify it, and therefore you generate another one. But the one that you're generating looks similar to the first one, but materially you have tampered with it. That's the issue. Now, in fact, the investigation clearly shows that there was no additional information in the second report. In fact, what happened is that there was certain paragraphs and content, material content for that matter, expunged from the first report to construct the second report.
But when you say that, what comes across to me is you are disagreeing with Mr. McBride's approach. You are disagreeing with his analysis. You are
Which analysis,
disagreeing with his recommendation. You say, I don't agree with this analysis. I don't agree that what was in the first report those paragraphs should not also be in this report. But he has taken a different view. I'm just putting a possible argument. He has taken a different view. So what's wrong with taking a different view?
No.
Do you punish somebody because they have a different view?
I'm not.
I want you to assist me where,
but
where I need clarification.
Yeah.
So in other words,
I think it's possible, Chair, that you might be missing a point somewhere.
yes,
A report, an investigation report, is not about views. It's not about.
but surely when they make recommendations, those are views.
Can I finish, Honorable Chair? The investigation report is not about views. What constitutes an investigation report are statements collected, sworn to statements, collected from individuals, analyzed to produce that report. So it's not about views. What my view is that this and so on. So if you have statements that clearly, whether it's one or two individuals, that implicate you in relation to allegations of the commission of crime, for an example. So you can't then say, I have a view about these sworn statements that actually you may not have committed that crime. It doesn't work that way. Now, and that's why, Chair, it's quite important, and I think I tried to emphasize this point on the first day, that all of us, we need to respect processes, because institutional processes, they are there to assist us. That's another level, for an example, which must determine your extent of involvement and or guiltiness, for an example, that must establish that. But on the basis of what is there, these are the implications and so on. So much as I hear the Chair from that point of view, but we shouldn't make it out as if it's, a general sort of analytical kind of report necessarily. It is born out of what is contained in the docket and all dockets.
Yes, you see, I have an issue with your evidence that a report such as that is not about views.
Okay.
I expect you to agree to this proposition that says, when an investigator, including an IPET investigator, has been given the task of investigating something, and they collect evidence, they collect statements from witnesses, and they're supposed to see whether there should be prosecution, or they should make a recommendation for prosecution or for misconduct, disciplinary action. They take a view on the content of the statement to say, what do I make of this evidence? Do I think this evidence reveals that this person committed a crime, that this person acted in breach of the rules of the employer? That's the view they take. And when they make a recommendation, and the IPET Act says they must make recommendations, that recommendation is the view they take. Somebody else might say, given this evidence in these statements, I recommend that so and so should be disciplined. Somebody else might say, given the same evidence, I recommend that this person should not be disciplined. So So that's where I'm coming from, and you will get a chance to say you agree or not, but I expect you to agree. But I'm therefore saying, when it comes to Mr. Sissoko and Mr. McBride, it seems to me, and I want you to tell me if I'm looking at it wrongly, it seems to me that there is room to say they expressed, to the extent that they were party to the final report, they may have expressed views. Some of those views or their approach might have differed from Kuba's approach alone writing that other report, and you didn't agree with their approach in the second report. You didn't agree. Your view was that they should have included certain paragraphs that they thought should be excluded, but it's the view they took. And if it's the view they took, must they be punished for the view they took? So what do you say to that proposition?
Honorable Chair, I would have really loved to agree and share your proposition, but I don't. And I'll probably also try and provide a simplified sort of, sorry, a sort of a example to try and illustrate this point. If you go out here in Johannesburg and you cross a red robot, now a traffic officer will stop you and will tell you, if you're lucky, but it will tell you that this is a violation of crossing a red robot and in violation of the Ordinance Act of 1960, whatever the case is, and so on, right? That's not a view. That's not a view. It's a, so you can't then say this traffic cop expressed a view which is different from me as a driver or from me as an onlooker to then say, yeah, he might have crossed the road robot and perhaps it's possible that he did not, and so on. No. So I'm saying institutions of policing in particular, Honorable Chair, they function against institutional regimes. In this case, your Criminal Procedure Act, your whatever act. Of course, I'm not an expert when it comes to these things, Chair. I was merely a political head of the institution, but it doesn't make me a policeman. But they will tell you, and they're professionals that are trained in this regard, okay? So you can't then say, those people having done so, again, in the background of our minds, having made this example about the traffic cop and say that was an expression of a view. No, it's not a view. In legal and criminal matters, and perhaps a view, I think at the level of yourself, Honorable Chair, as a judge, I mean, you can, in analyzing the law and so on, but these are law enforcement agencies. That's all that they do.
That's very interesting to say that because remember, a police officer who sees what he may think, she may think is a violation or contravention of a traffic regulation or law,
Yes, sir.
may come to you and say, why are you doing this? Why are you crossing the robot? And if you give him or her a certain answer, he may decide, no, I understand this, so therefore I'm not going to arrest you, I'm not going to charge you. You say people are chasing me, wanting to shoot me, so that's why I'm running away from them. If you give them a different answer, they might say, no, there's no valid reason, you'll have to face charges. But I think let's not take it further. I understand what you say, and I think you understand where I'm coming from.
Yeah.
Mr. Halley?
Thank you, Mr. Chair.
Thank you, Chair.
Now, you, if I understand your testimony correctly, you decided to take disciplinary charges against Mr. arising out of the Worksman's report, to take disciplinary institute disciplinary charges against Mr. McBride, but not against anybody else. Do you understand that correctly?
I took disciplinary steps against Mr. McBride.
And who else?
Against Mr. McBride.
Anybody else other than Mr. McBride?
I think he said nobody else. Yeah, nobody
Oh, sorry, I
else.
thought he said, sorry, my.
Yeah,
Mr. Chair,
others
my
may have been
apologies.
suspended, but it was not his decision. That's what he said.
What about General Dramat, General Sabia, Captain Maluleka, any of those?
No, the others would be outside of my ambit, really. Of course, yeah, General Dramat, you know, I had already indicated to that. But with regards to the others below him, it had to be somebody else, not me.
What I'm trying to understand as far as this is concerned, you commissioned a report to investigate whether there were criminal and whether there was disciplinary misconduct on the part of a variety of people. Those people included Mr. Sissoko, Mr. Kuba, Captain Maluleka, and General Sabia. All outside of your mandate, or all outside of your scope of, as the employer, outside of your ability, your power to discipline them. Correct?
Yes, some of the individuals that you mentioned.
All or some?
No, I'm saying some of the individuals
Which
that
ones
you
do you
mentioned.
disagree with? Which ones do you disagree with? I've named 4.
Just run down that
I
list
think
again.
Mr. McBride was the one person
Yes.
he said he had power to suspend. Mr. General Dramat was another person that would have fallen within his power, but by the time, I think he had suspended him earlier than the workman's report.
Right.
Yeah, I don't think there was anybody else who fell within your power to suspend, is that so? Among the people mentioned.
And I think we should also qualify this, Chair. General Dramat, it was more to do with being implicated in the commission of crime.
Yeah, not
Right.
in the
But
report.
then not the question of the 2 reports
Yeah.
and so on. And I
Yeah.
think we
Yeah.
need to be able to
Yeah.
draw the line between
Yeah.
the 2, Chair. Thanks.
In the terms of reference, you were concerned firstly about the rendition matter, and that involved General Dramat, General Sabia, Captain Maluleka, and perhaps other individuals. But you identified 2 specifically. You spoke about General Dramat and General Sabia.
Yeah.
You were also concerned about the circumstances which gave rise to the amendment of the IPID report. And as far as that was concerned, you were concerned particularly about the fact that there were 3 people, and that was Mr. McBride, Mr. Sabia, and Mr. Kuba. Sorry, Mr. Sissoko and Mr. Kuba. Correct?
That I was concerned about what?
In relation to the two reports.
Right.
Correct?
Correct.
Now, what I'm trying to understand is how you on what basis you commissioned an investigation or into misconduct. Let's focus specifically on misconduct. Into misconduct of people who did not fall under your power or authority to discipline.
Now, there is absolutely nothing wrong with investigating, and in the investigation, people that you do not have a direct supervision on are implicated. So you wouldn't say, oh yeah, these people are implicated, but because I have nothing to do with direct supervision over them, so they should not be subjected to disciplinary hearing. That would be incorrect. In fact, remember that in the position that I was in, I was responsible in overall of the portfolio. So if I felt that, not even felt, because I remember the chair and I, we were talking about feelings and views. So I must be careful in terms of what I say here. So you have an investigation that then points out that in the division or the unit that I am supervising, you have an XYZ kind of person who is alleged to have committed the following whatever. Now, you refer that matter to the supervisor concerned. You say, here is a report that says the employee that you're supervising is implicated in the commission of an offense, a certain offense, or misconduct, and so on. And that person, manager and supervisor of that employee, would then need to roll out a process of dealing exactly with that issue. Okay. So, but there's nothing wrong in identifying that, there's, there's either report or whatever that identifies the people that are not even supervising who are part of, who are implicated in the commission of an offense and so on. There's absolutely nothing wrong in that. And there's a difference, for your benefit, Mr. Hardy, there's a difference between what I've just said and I then saying, I'm now issuing disciplinary charges against those employees that are being supervised by this other employee that falls under my supervision. There's a difference between the two. Thanks very much.
You see, the difficulty is the investigation wasn't exclusively into Mr. Robert McBride's alleged misconduct or Lieutenant General Dramat's alleged misconduct. Mm-hmm. You were investigating, or your terms of reference made it clear that you were investigating several people in the DPCI, which included Dramat, Lieutenant General Dramat, General Sabia, and others within the DPCI. And in relation to IPID, you were investigating not only Mr. McBride, but you wanted others within the IPID to be investigated as well. Would that be fair to say?
No. I think you're wrong, Mr. Hale. Absolutely wrong. We were not investigating certain individuals. We were investigating a circumstance that said, how come you have this report and then you have this one? Right? So, was the manner in which you crafted it, it's as if, I must have looked at you, Chair, and said, no, I want to investigate you. No, it doesn't work that way. there is a particular circumstance and an occurrence that took place. And the question was, let us establish the facts around this. So, in the process, of course, of the investigation, it then begins to reveal players in the occurrence of a particular circumstance. And it's on the basis of which then a particular institutional process has got to take place. So I wouldn't like Mr. Halley to understand this thing as trying to individualize it and say, no, there were certain individuals and specific people that were being investigated. There was an occurrence.
You see, the difficulty with that is, if I understood correctly, the investigation was specifically twofold. It was an investigation into criminal misconduct, and it was an investigation into disciplinary misconduct. Correct?
Yes, it covered both angles.
And it related to, you wanted to know if there were any people from IPID who were implicated, or any people from IPID who may have been guilty of the criminal or the disciplinary misconduct.
Don't forget your answer. I just want to say we are at 2:25. Okay, all right.
Thank you, Mr. Chair.
Yeah, give your answer, Ms. Nhleko.
Can you reformulate that question? No, not reformulate it. Put
You want
the
him to
question again.
repeat it? He's asking you to repeat the question.
Thank you, Mr. Chair. Let's consider the terms of reference.
No, just ask the question, Mr. Halley.
You were
I think
concerned with
we've
criminal.
gone through the terms of
intervention
reference, so there's a question that he posed. Now,
Yeah,
that's what I'm interested
My
in.
intervention disturbed,
Thank you, Mr. Chair.
yeah.
The purpose of the investigation, insofar as IPID was concerned, you wanted to know specifically what were the circumstances which gave rise to the changing of the report from the first report to the second report. And you were specifically concerned with whether who were the individuals
Right.
that may have been involved in doing so, and the circumstances which gave rise to the changes, and who are the individuals within IPID that may be guilty of criminal or disciplinary misconduct. Is that right?
Yes, that's correct.
Now, I would have been, given the attitude or the testimony that you've given here today, it would have, and your acknowledgement that you had no power over anybody other than Lieutenant General Dramat or Mr. McBride, I would have expected that the investigation would have been into whether Mr. McBride committed misconduct or whether Lieutenant General Dramat committed misconduct.
Oh, Mr. Halley, I've responded to that question, sir. I
Yes,
went to,
I think you have.
yes, I even made examples,
But
Chair.
I think maybe Mr. Halley wants to, you are suggesting and you want to know whether he has got any comment to your suggestion.
Indeed. It's a proposition that I would obviously, and what you must appreciate, sir, is that at the end of
Because
this,
his answer was, there is a situation that had arisen and it was necessary to establish what happened, how the situation came about, who, if anybody, was had committed misconduct or an offense. And it so happened that in the course of that investigation, obviously persons who had had a role to play would be asked questions. I think that is what he said, yeah, I'm putting it in my own way. But Mr. Hall is suggesting that he would have expected you to confine the investigation to the persons who fell within your authority in terms of disciplining, namely Mr. McBride and General Dramat. You may be able to say, I didn't see it that way, or I thought it's necessary to look at everybody that may have had a role to play. Do you want to say anything?
No, I disagree with his proposition.
suggestion.
Yes, I actually do. And in fact, even earlier on, I did allude to the mere fact around the issues of oversight responsibility. You know, so,
Okay.
Thank you, Mr. Chair. And on what basis, I'm trying to understand this, on what basis, given that you understand, you appreciate that you have no command over, or direct command or operational command over Mr. Kuba, on what basis do you phone him and tell him, instruct him in fact, to cooperate with the Worksman's investigation?
no, on the basis that there was an investigation and he needed to cooperate with the investigation.
No, I understand that. In the same way that I can phone, one can phone up anybody else. But the question is, on what authority do you do so?
On the basis of the overall responsibility that I had as mandated by the Constitution and the oversight responsibility of the department.
So your earlier testimony was, yesterday, your testimony was you don't phone people that are lower down in the rung. You phone the person that's at the head of that institution. Now, in the case of IPID, that was Mr. Khamanyani when Mr. McBride was on suspension. So what I'm asking you is, if you wanted an instruction to be given to Mr. Kuba, why didn't you phone Mr. Khamanyani?
No, you're getting it wrong. At the time when I called Mr. Kuba, Mr. Khamanyana was not on the scene. If
Thank you,
my
sir.
recollection, if I'm correct, I mean, he was not there. So I think
Who was the head?
it was Mr. McBride. Who
So why
himself-
did you phone Mr. McBride?
Yeah,
No,
I think
who
that's my
himself-
recollection as well. That's my recollection as well, that it
Yes,
was Mr. McBride.
yes, it was Mr. McBride, who himself was also implicated in the very same issue of the investigation.
That's the point. And the point is that you bypassed Mr. McBride and went straight to Mr. Kuba. And, now there could only be one reason why you could have gone directly to Mr. Kuba to instruct him to cooperate with the investigation,
Right.
because you suspected that Mr. McBride was guilty of some wrongdoing. Correct?
No,
I'm sorry, just repeat the question.
There's only one reason why you would have bypassed Mr. McBride and gone straight to Mr. Kuba, was because you suspected that Mr. McBride was guilty of some wrongdoing.
No.
He suspected that Mr. McBride had done something wrong.
That
That-
Mr. McBride was the one that was guilty.
Okay.
But Mr. Halley, you would appreciate this thing. Guilt is never suspected. The guilt is established through processes. So I can't look at you or any other human individual and suspect guilt. It never works that way. However, you could be a person that is implicated in the wrongdoing. And I think those are the guarded kind of terms that are used, but the usage of the concept of suspected guilt defeats the whole notion of why you need to have institutional and or legal processes that must then establish whether you're guilty and to what extent and whether you're not guilty. That's it. That's my understanding of general practice, basically.
And I accept that. You've obviously got to establish it, but one could have a suspicion. Nothing wrong with having a suspicion. Your suspicion could be based on nothing, and of course your suspicion could be based upon something.
Mr. Hale, I think let's agree that we disagree on that.
Let's move on.
I mean, for me, as I say, I mean, you can't suspect guilt. You know, wrongdoing, yes, you can suspect, but not guilt.
Now, the second question is, if you knew that Mr. Kuba you had been told that Mr. Kuba wasn't cooperating, I would imagine that you would also be told that Mr. McBride wasn't
Chair,
cooperating.
if Mr. Hali can indicate when is he going to finish, because you've given him time, he's just continuing and eating into the re-examination.
Yes, I was also looking whether that was
Yes.
going to be the last question or what. We are at 25 to 3. I'm not saying stop abruptly. What is the situation?
Mr. Chair, if you would bear with me. Yes, I think I'm down to basically two propositions, and then I want to sum it all up.
Is that 5 minutes or how much is that?
I don't
10
think it's-
minutes?
I think it's, depending on the answers, I would think that it's about 15 or 20
Yes,
minutes.
but we've got to come to some conclusion.
Absolutely, Mr. Chair. The difficulty, as I said at the outset, is that I'm making an assessment in my head, but then my assessment is based upon a response that would be relatively short.
Well, we have got to come to some
Absolutely.
conclusion. I don't want to say abruptly stop. Well, can you try and see if you can wrap up in 10 minutes?
Thank you, Mr. Chair. If I could ask you, sir, to turn with me to your founding affidavit, your affidavit, which is in bundle LEA 1.
And I think I can say the 10 minutes is the last 10 minutes. So I just want to make sure that you
No,
know
fair
that
enough, Mr. Chair.
that will be the last 10 minutes.
Thank you, Mr. Chair.
Yeah.
That's bundle LEA 1, sir. Have you got it?
Well, I think you can go ahead and ask the question. He will decide if he needs it. If he's able to answer without looking at it, he will. I think that's his approach.
Thank you, Mr. Chair. In your affidavit, you deal with the worksman's report at some length. And I could just refer you to the relevant page.
Remember that you might not need to refer. If you know what is in the page, you can just put the question.
Thank you, Mr. Chair.
He might be able to answer because you probably know what the question is you want to put. So,
Well, my understanding arising out of the affidavit was that you had, pursuant to obtaining the Worksman's report, you had decided to institute disciplinary proceedings against the implicated individuals. Do I understand it correctly?
I think this point has been covered, Chair.
I'm sorry, I didn't hear the question. What was the question, Mr. Halley?
The question, Mr. Chair, was that my understanding of the affidavit was that Mr. Nhleko, having received the Worksman's report, had decided to take, to institute disciplinary proceedings against the implicated individuals.
Well, he
To which,
certainly has said that he only made the decision to suspend Ms. Deborah McBride after the Workman's report.
Thank you, Mr. Chair. In your affidavit, you say the following: the report and its conclusions and findings was given to me as the Minister of Police for information. The Worksman's report is attached here to and marked in 1. It is on the basis of this report that I commenced further disciplinary processes against the implicated individuals.
Is it individuals, plural?
Correct?
Okay. And what was the verb? It says he decided to what?
Institute disciplinary proceedings against the implicated individuals.
Individuals, okay, all right. Mr. Nhleko?
So what is it that needs to be known about that, Chair?
He says, and I'm paraphrasing, you have said that after the Workman's report had been presented to you, the only person that you decided to take disciplinary action against, and here I'm talking about suspension, was Mr. McBride. But he is saying, in your affidavit, you said you decided to take disciplinary action against the implicated individuals, plural.
Yes, Chair, but the point being
Yeah.
that the investigation report by Worksman makes a reference to the alleged sort of areas of misconduct by the individuals that are concerned. So I agreed with it, and I agree with it. So this particular paragraph that he makes reference to, it's precisely because I agree with the original recommendation that says disciplinary action must be taken against the following individuals, okay? Now, and I think I've explained earlier on, the whole question of the distinction between disciplinary steps as a supervisor that you take against an employee that reports to you, against the situation where that particular employee takes disciplinary steps against people that report under him. That's it.
Thank you, Mr. Chair. And after the matter went to the Constitutional Court, this is now, Mr. McBride instituted proceedings in the Constitutional Court to set aside his suspension after you had suspended him, and he did so on the basis that you had no power to do so. Is that correct?
Honorable Chair, I do think that we need to be careful as to how we talk to issues of judgments. We are sitting in front of the Deputy Chief Justice here, who's also part of that very same matter and is part of that very same order. So, Mr. Halley, you would know that the Constitutional Court did not set aside his suspension. And as a matter of fact, there is no, in all the courts that Mr. McBride went to, there was never a pronunciation on the issue of his suspension. Now, the Constitutional Court made the following order, because I think we need to clarify this point.
But I don't think you need to read it. I think your point is it pronounced on the constitutional validity of certain statutory provisions.
Yes, Section 6.
That's the point you want to
subsection
make,
3,
yeah.
Yes. So, that's all that it did.
Yeah.
And instead of, maybe let me not read it, because
Yeah,
I know
no, don't read it because
I can bore you.
in terms of time.
Yes.
Yeah, but the point you
instead-
make is,
Instead, what the Constitutional Court said two things, largely. It said, look, Section 6, subsection 3, and other provisions are being, for lack of a better word, are being shifted aside and in their place, in particular Section 6 of the IPID Act, Section 17 DA of the South African Police Act must be read in there, right? And then said, on the issue of the Minister of Police taking disciplinary steps, that matter, Parliament needed to deal with it within 30 days, and it was for Parliament to then decide whether within the prescribed 30 days by the Constitutional Court, whether it's still, both Parliament and the Minister of Police, whether they still wanted to pursue disciplinary charges against Mr. McBride. So, Mr. Halley, in that order, where is the suspension that is set aside? Because the only thing that happened, by the way, I'll tell you what happened. The only thing that happened, you had an institution of state, a democratic state, that did not follow this order to the letter, and that is Parliament. It elected not to do anything. I mean, it's either you take a position that says, yes, you agree or disagree, but you can't just be mum when it comes to matters of an order such as this. Now, and I think that's where fundamentally also my problem was, and even for that matter, conceptually, I seriously have a problem with a situation such as that. But it happened, okay? Now, the consequence of which was that because the prescribed 30-day period by the Constitutional Court lapsed, there was nothing in law or in any other measure you can think of that then prevented Mr. McBride reporting for duty and going back to work, right? So there was no setting aside of a suspension and no reinstatement, as it has been somewhat alleged
Mr.
in
Chair, if
other
I can just be
courts.
fair,
So
because that
that's
was
what the
not the
order
question
says.
I asked.
Yes,
I've
yes.
got a 10-minute response to a question. The question was whether Mr. McBride had instituted proceedings to review and set aside his suspension.
No,
I've been told about the Constitutional Court and
Honourable
what they
Chair,
ordered.
I disagree with this, because he, in the formulation, Mr. Halley, pointed directly to the question of the Constitutional Court having set aside his suspension. And that's the point that was clarified.
I can't say I remember whether it was that or it was simply saying Mr. McBride brought
Which I
an
said, and
application.
that ultimately
But I
went to
don't know
the
if it,
Constitution.
I don't know how much it matters in terms of what you have in mind, Mr. Halley. If it's important,
Thank you, Mr.
you
Chair.
can use it to wrap up.
The point is, as you've already pointed out, what the Constitutional Court had ultimately declared was that National Assembly was the body that was responsible to determine whether Mr. McBride could or could not be suspended. Now, it's not your fault, of course, because at the time at the time, it indicated, the IPID Act indicated that you did have the power to suspend him.
No, the IPID Act did not indicate. It said the Minister of Police as the following whatever. So it was very pointed. It's not an indication, Mr. Hali.
The powers.
The powers, yes.
Yes.
Yeah.
But then that was done away with by the Constitutional Court. And the
Yes.
Constitutional Court said that those provisions were unconstitutional,
Right.
which meant that you know that whatever powers you might have had or believed you had, you no longer had. And yet you continue to pursue the matter. Not only did you approach the National Assembly, having been told by the Constitutional Court that you actually didn't have those powers, not only did you approach the National Assembly to try and advance your case, but when the 30-day period lapsed and Mr. McBride returned, you suspended him again. You wrote a letter saying that the National Assembly must decide where Mr. McBride must go to, correct?
Hey, I don't believe this. Now,
That will be the last question, Mr. Hali.
yes, just two things about what Mr. Hali has just said.
I think in effect he is saying, is it not true that after Mr. McBride had returned to work, you suspended him again?
No, but Chair, he started somewhere.
Yeah, no, he started somewhere. You
He
can
then
deal with it,
says that he finds almost something wrong with the fact that I approached Parliament. I was approaching Parliament in compliance with the Constitutional Court order. And all I was saying to Parliament, Parliament, comply with the Constitutional order. This is an order. If an order is issued, we all follow the order. Simple. So you can't subject, for an example, an order to any other set of emotions, whether they're political or something or otherwise. It's an order, so we had to comply with that. Because it said Parliament and Minister of Police must then decide whether they still wanted to pursue this.
Yeah,
So in his formulation, Mr. Hali, that is,
yes.
he insinuates that there was something wrong with me doing that by approaching Parliament, which is incorrect.
I think I understand your
Yes.
point. I do want to bring this to an end so Mr. Mukhari can re-examine. I did indicate to Mr. Hali that that was to be the last question.
And then,
I think I gave him more than the 10 minutes that I said was going to be the last 10 minutes.
Yes, Mr. Chair. I'm quite happy, of course, on your instruction, Mr. Chair, to conclude it at this point. Of
Yeah.
course, I did want to afford the
Yeah.
witness an opportunity to deal with that.
Yeah,
And of course, the opportunity, because it's in the affidavit
Yeah.
that he's dealt with, that it's part of the,
No,
it's
that-
part
that-
of the
that-
statements that he's dealt
yeah.
with.
No, that's fine. We've got to end here. What's the last point you want to say, Mr.
no, the last point is in relation to Mr. Hali's assertion that not only did I approach a Parliament and so on, that even after he returned, I suspended him. That's factually incorrect. Absolutely incorrect.
Yeah.
Indeed, I did then write to the Speaker of Parliament and said, look, in the light of all these issues and the happenings in the manner in which they have happened, they must then, as the institution of Parliament, decide as to how they wanted to deal with that issue. Okay. I had done
The issue of
almost...
suspension.
No, yes, the issue of suspension.
Okay.
Now, I had done almost everything in my power to approach them and said to them, this is what the Constitutional Court says. Let's comply with it. Now, and by so saying, Chair, I was not saying they should not, as Parliament, agree with my position. I was saying they have got to pronounce. Pronounce whether you want to do this thing or not do it.
Yeah.
You know, between the two. And I think even the court itself would have then been satisfied that the order was complied with. But you can't just leave it hanging out there and so on. And that's my problem, you know.
Okay, all right.
Mr. Chair, just to be fair to the witness, and of course, Mr. Mohari can deal with it, the relevant passage that I'm referring to is a press statement issued by the witness. It appears in bundle LEA 8, and it's at pages 3639 to 3641.
Yeah, okay,
So
that's fine.
it's dealt with over there.
Thank you.
Mr. Chair.
Mr. Mkhari, re-examination?
Thank you very much, Chairperson, for the opportunity. I just want to ask Mr. Nhlako just a few questions,
Yes,
purely for clarification.
yes.
It's not necessarily a re-examination.
Yes. Thank you.
Mr. Nhlako, when McBride brought an application in the High Court to declare Section 6, subsection 6, right with Section 6, subsection 3 of the IPID Act unconstitutional, and those were the sections which gave you the power to suspend him and also to institute disciplinary proceedings against the executive director of the IPID. You opposed that application, am I correct?
Yes, that's correct, sir.
And you filed an answering affidavit.
Yes, that's absolutely correct.
And in that application, McBride did make allegations of ulterior motive, and as well as that you were suspending him for, or you're malicious or all those type of things. And you filed an answering affidavit and responding to those allegations in detail. Do you remember that?
Yes, I do remember, sir.
And what happened to those allegations in court?
He withdrew them.
I didn't hear the answer. Just
No,
speak.
I'm saying he withdrew those allegations of ulterior motives, and I think it was ulterior motives and something else, I can't remember. But
Yes, that's fine. I just wanted to know then what happened to them. That's all.
no, he withdrew those
Yes, that's right.
claims.
Okay, all right. And then the High Court delivered a very lengthy judgment. In essence, it declared Section 6, subsection 6, right with Section 6, subsection 3 of the IPID Act unconstitutional. And on the basis of that, it then found that you had no power to suspend McBride, and similarly, you will have no power to institute disciplinary proceedings against him because those provisions of the law were not consistent with the independence of IPID, which ought to be insulated in it in terms of the Constitution.
Right.
Did the court make any finding against you of ulterior motive?
No, there was no such a finding.
Now, in respect of the suspension, I know that you're not a lawyer, but we have a judgment here, and the chairperson will be able to read it. And the High Court did set aside the suspension of McBride. But what I want you to comment on, what did the court say about his suspension? did it say that McBride now is free to go back to his position as executive director? Or did it say something else?
I think the better yes was pronounced upon by the High Court, but pending a constitutional challenge. The effect of which was that the suspension itself was not set aside, but I think I'm subject to correction in case I'm missing something here, but that's
Yes,
my
of course, then I understand that you don't have the judgment with you, and I don't want us to waste time on that. Chairperson, the paragraph of the judgment will be paragraph 77, sub 6 of the judgment. Paragraph 77, sub 6 of the High Court judgment. So all what the High Court said was that although it has set aside McBride's suspension, but McBride must remain on suspension until such time that Parliament has looked into the matter. If indeed the suspension was such of magnitude that McBride ought to return to work, what is it that the court considered that although McBride succeeded in his challenge, he must still remain on suspension?
No, I didn't hear you, Mr. Mukari.
The question is, since the court, that is the High Court now, said that Mr. McBride mustn't return to work until Parliament had dealt with the matter, what are the considerations that led the court to saying that? That was the question.
Yes, why would the court do such a thing? That's the question.
Of course, the answer would be in the judgment, I would imagine. And I think, Mr. Mukari,
Yes, so
you
with
can fill.
I mean, issues of like the allegations, I mean, what was the nature of the allegations, all those type of things? That's
Well, I want to say, Mr. Mukari, I want to say, anything that is in the judgment, you are free to just draw my attention to what the court
Or
said,
to what the
even
court-
if he doesn't deal with it. If
Yes,
that's what
in
you want
fact,
to
I'll,
taken into account, you mentioned where it is
yes,
to be
indeed,
found.
yes. Chairperson, from the High Court judgment, paragraph 60, paragraph 67, 68, and then 77, in particular, 77.6. So 60, 67 will then deal with the considerations that the court took into account, but essentially then the court was alive to the fact that the minister pointed out to the nature of the allegations against him, the seriousness, and that McBride himself said that I am prepared to face the disciplinary proceedings. So the issues of the charges, that there was no issue of the charges being frivolous or baseless, then that's what I was trying to put to you, Mr. Nhleko.
Okay, okay. It's because the court had also recognized that the allegations were of a serious nature.
Now, so in terms of our legal system, when the High Court set aside or declare a provision of statute unconstitutional, it doesn't become effective immediately. The Constitutional Court must have a final say, and this matter of McBride was then taken to the Constitutional Court for confirmation. Again, I'm not going to deal with the Constitutional Court judgment because it is there, and then the chairperson will be able to read it. But then what was before the Constitutional Court will be the material that was before the High Court. The paragraph that I'd like to take you to, but again, because of time, I'll read it for you, is paragraph 12. And this was a judgment delivered by, it was written by the late Honorable Busielo A.J. In paragraph 12, it says, faced with the glaring discrepancies in the two reports, the minister suspected serious tampering. As a result, he commissioned Waxman's attorneys to investigate the two reports. Relying on the January report and the investigation by Waxman's, the minister invoked his powers in terms of Section 6, subsection 6 of the IPIT Act, the Public Service Act, and Chapter 7 of the SMS Handbook, and placed Mr. McBride on precautionary suspension on 24 March 2015, acting on the strength of Section 66A of the IPIT Act, read with the provisions governing disciplinary proceedings under the Public Service Act and the IPIT regulations, the minister served Mr. McBride with a notice to attend a disciplinary inquiry. So the Constitutional Court, of course, is here mentioning the factual situation. It's not dealing with the law. So the only way the Constitutional Court would have said this is because it found it from the papers, and that's what you have said in your papers. Am I right? That you're faced with two reports, which are conflicting, and you suspected serious tampering.
No, absolutely so. But also, I think, as I had said before this commission, the Honorable Chair, that from an institutional responsibility point of view, there is no way that you could have ignored the existence of two reports and the disjuncture between the two of them. And therefore, it was important to clarify oneself around this particular issue. And for purposes of clarification, you then had to institute a particular process towards that point of clarity.
Yes, but also importantly, which you also have to know, well, you have touched it when Mr. Hali was asking you questions, but again, because you're not a lawyer, you're not able to know the exact phraseology of the order. The Constitutional Court did confirm the the High Court order. But importantly, I would like to refer you to paragraph, which is now then the paragraph of the order, 58, subparagraph 4, and that is only in respect of the suspension. Then paragraph 4, then it said, it is declared that the decision of the Minister of Police to suspend Mr. Robert McBride from his position as Executive Director of the Independent Police Investigative Directorate is invalid and is set aside. So I just want to make it clear to you that the court did set aside his suspension.
No,
But what follows, but what is important is what follows. That is now paragraph 5. Then in paragraph 5 it says, the order in paragraph 4 is suspended for 30 days in order for the National Assembly and the Minister of Police, if they so choose, to exercise their powers in terms of the provisions referred to in paragraph 3.1 above. Now remember the proposition that was put to you by Mr. Hali, because he was saying to you, despite that the Constitutional Court has set aside the suspension, you still forged ahead and went to Parliament. And your answer was that you're acting in terms of the Constitutional Court order, but you could not refer to a specific paragraph of it.
right.
And so this is the paragraph that actually then will have prompted you to go to Parliament, because you have said that the Constitutional Court did what, as the lawyers would call it, a read-in.
Yeah.
Because section 6663 are no longer there. They cannot be used, but you can't leave a vacuum. That's what the Constitutional Court says. And then it says, what can we do in the meantime whilst we're giving Parliament an opportunity to rectify the legislation? It says that we will now read in section 17DA. Am I correct?
Yes, that's very correct.
And so then you say that you acted in terms of that section, and again, the chairperson will be able to read section 17DA and see for himself that section 17DA of the Police Service Act, it actually requires a joint action. That is not the minister and Parliament must together act then to trigger either a suspension or additional processes. It can't be you alone. So that's what really they need to say. Am I correct?
That's very correct, sir.
So you are basically, in your response to Mr. Hali, you're basically saying to him, I've done my part. I've gone to Parliament because I wanted to be complying with the Constitutional Court Order Paragraph 5, which said that Minister, Parliament, you have 30 days, make a decision. Are you going to charge this man or not? And you say you have done your part. What did Parliament do? Did Parliament do its own part?
No, certainly it did not in this particular instance.
Now the question is, can you tell the chairperson what would have happened to McBride's suspension had Parliament done its part?
Look, that suspension, of course, if we acted in accordance with the Constitutional Court order, the Constitutional Court order, gave us a period of about 30 days to, Parliament and the Minister of Police, myself at the time when I occupied the position. That suspension would have stayed on, but the decision, perhaps by Parliament, would have been the question of processing the issues of discipline. Okay. Now, suppose the decision by Parliament would have been, yes, let's go ahead and, these are the charges and so on, and let's deal with them. So suspension would have gone on beyond that 30-day period as per the Constitutional Court. In fact, the Constitutional Court order, the 30-day period was not about suspension. It was about rectify and deal with the procedural issues within the 30-day period and see whether you want to proceed or not proceed with the disciplinary action against Mr. McBride.
Okay, thank you very much. Now, let's move to Dramat because it was also something which came up during your testimony. Mr. Hali did ask you about your suspension of Lieutenant General Dramat. We know that the Helen Suzman Foundation challenged that suspension of McBride by yourself in the High Court, and there was a judgment by Prinsloo J. You also opposed that application, am I correct?
Yes, that's correct, sir.
And Prinsloo J came with a judgment. So the only thing that I want to ask you in respect of that judgment, you have had an opportunity to also read it at some stage. Did Prinsloo make any finding that you acted with ulterior motive or malice when you suspended Mr. McBride? Lieutenant General Dramat.
No, there wasn't such a finding.
Again, it was a simple question of interpretation, your interpretation of the provisions of the South African Police Service insofar as the powers of the minister to suspend the head of the Hawks.
Yes. And may I also just state that, Honorable Chair, because this assertion has been made over and over again, that I acted unlawfully, which is a very strong statement by anybody to say. Because acting unlawfully would mean...
suspending General Dramat.
Yeah, but also Mr. McBride.
Yeah.
Yeah. Now, because acting unlawfully would actually mean you acted either against the provisions of the law or outside of the law. I think that's what it would mean.
Well, acting unlawfully may mean, depending on the circumstances, I mean, it means your actions were in breach of the law.
Yes.
But there are circumstances where you may act unlawfully but genuinely, believing that you are entitled to act in a certain way, even sometimes with the benefit of senior counsel's advice. So you go to senior counsel and he says, you say, if I do this, am I within the law?
Right.
He gives you an opinion and says, you will be within your right, you will be within the law if you do this, and he charges you an arm and a leg. You feel confident, you go and do it, and then you are challenged. The court says, no, you acted unlawfully. So sometimes you are genuine. It doesn't mean you are malicious. but it is unlawful. But sometimes it might be a situation where you were malicious or and so on.
No, thank you very much for the education.
Yeah.
Thank you very much. The point for me.
Unfortunately, if he was giving you the advice, he would charge you.
Yeah.
Not charging you.
That's for that. No, but the point I wanted to make, nevertheless, I'm sorry, Mr. Mkari, if I must have
Yes, fine, can proceed.
intervened. But the point I wanted to make is that in all these courts and their related sort of cases and processes, there is no court that said I acted unlawfully. And I
No,
think
not
that-
unlawfully. You acted unlawfully when you use a provision of the law which the court says is not consistent with the Constitution. What the chair is putting to you is that unlawfully is something, to us as lawyers, is not something that is offensive.
Okay.
But the problem is if you have acted with ulterior motive, malice, bad faith, then that's where the problem comes. So then your proposition should rather be that the court never said you acted with ulterior motive, malice, but unlawfully the court has already spoken on that.
You see, the president and the ministers, cabinet ministers, very often they are involved in litigation and the court says they acted unlawfully. But as long as the court hasn't said the minister or the president was acting maliciously or in bad faith or dishonestly, they accept that it's part of their job. Well, some of the things they do, meaning well, will be found to have been done unlawfully. So it doesn't necessarily, you shouldn't necessarily feel embarrassed if a court says you acted unlawfully, unless it's a situation where it says you were malicious, you acted in bad faith, or you had ulterior motives, then that's different.
No, thank you very much.
Then I just want to move to the two reports because there was a lengthy engagement between you and the chair, which was quite enlightening. But I just wanted to clarify so that, we are clear about what is your thinking around the issue of the two reports. If you remember the engagement between you and the chairperson yesterday, the chairperson was putting a proposition to you and saying, look, we have this IPIT institution which has two reports. And it follows that there shouldn't be really an issue about that because logically, you should simply say that the last report is their final report. And so what is the fuss there? So can we get your clear understanding there in the context of your understanding of what are IPIT reports there for?
My understanding, which is that our earlier discussion, I'm sorry, I would refer to it as a discussion with the chair, because there are various theoretical points that were being thrown in the air as part of that engagement, is that for me, I think your articulations, they sounded on the general side of things, and I think I must have pointed that one out. But with regards to reports of this nature, which are either criminal or matters relating to police misconduct and so on, they will essentially be based on factual material. Now, the factual material being the material that you find in the docket, and what you find in the docket are statements from individuals that state certain things and perhaps implicating certain people. So that's the strength. And I think I alluded also, Mr. Mkari, to this point, that in case there is a material shift, in other words, somebody made a statement implicating X, but then turns around and says, no, actually I was wrong. X wasn't there and maybe I lied and whatever the case is. So that materially registers a different sort of conclusion in a particular way. But it is also to be expected that when you find, whether is it a follow-up or the second report, you would have to refer to the first one, whether you are withdrawing it or annulling it or amending it. I think that's what practice is and so on.
Yes.
So I was trying, Mr. Mkari, earlier on to draw the distinction between constructing what I would call a general report based on, or not so much of a material and so on, as opposed to an investigative report and so on. So I think our engagement earlier on were about that. Yeah.
Yes, but I think but then what you could appreciate from the engagement with the chairperson is that in this type of things, a debate can go on, and you may have different views.
Yeah.
But then the questions that I'm going to, and that's now then is I mean, it is in conclusion, are the following questions which I'd like you to assist the chairperson with. Suppose when you got the two reports, you then looked at them, in your mind you said, I can't have this constitutional institution producing two contradictory reports. What will this send? What message will this send to the public? And you become angry maybe as a minister, or you become furious. You say that I can't have this type of situation. I want to get to the bottom of this.
Right.
But somebody may say that, no, but you're overreacting. There's nothing wrong man, with what they were doing. But in your thinking at that time, you believe that this can be done.
Yes.
Is that now then, but my question is, if you are found later that in fact you are wrong, you should not have done anything, but you have done something, we know you have done something. In what way will that become a state capture? So that's what I want to, because I know that we're not here in a court of law. We're not here running a trial. We're here in a commission of inquiry which is focusing on a particular issue of a state capture. So can you assist the chairperson in that context?
Honorable Chair, I've always viewed this matter, specifically this matter, not the state capture issue, the matter around Mr. McBride and others and so on, as purely as nothing else, employer-employee relations. Now, it is natural in industrial relations practice that it's a natural thing that there will be disputes that also arise in the employer-employee relationship and so on. So this matter to me still remains that. The most unfortunate thing is the manner in which it was handled. I'm now meaning, the happenings outside this particular commission and so on, which I wouldn't want to bore this commission about what happened and who said what, where, and so on and so it goes. But the most unfortunate part was that the consequence of which was that what was due to the public to be known as the actual truth out of this matter, the public was deprived because the mishandling of the whole affair meant that you could not, the processes that were supposed to establish the whole question of what happened to the two reports and so on, and who's to be held accountable for the discrepancies and so forth, never actually occurred, right? So that's why I'm saying the public, members of the public were then deprived of the actual truth about this thing. But the allegations are very serious and they still remain extremely serious. Now, but the suggestions are that, in fact, I also wanted to address the chair about this question of the suggestions of the state capture. Now, Mr. Mkari, the allegations against myself are extremely serious because Mr. McBride came here and said, I captured the criminal justice cluster. Now, the criminal justice cluster, just for your benefit, Honorable Chair, It is the National Defense Force, it is Home Affairs, it is Correctional Services, it is State Security Agency, it is the South African Police Service, it is the National Prosecuting Authority. Now, at least at the time when I was there.
And justice? Is justice not part of
Oh, yeah, justice. Oh, yeah, no, I'm sorry. And I know why, Chair, you're quick to pick up that justice is not mentioned. I understand that. So, yes, and the Department of Justice. So, that combination, at the time I was there, I'm not sure now, but at this time I was in government, that was your criminal justice cluster. Now, if you say I've captured the criminal justice cluster, you are then saying, I, as Minister of Police then, I had the power to decide on the issues of prosecution, which is not true. It's not even allowable by law, okay? So, even constitutionally, it's something that cannot happen. It just doesn't. Now, my misgiving, though at some point was when I was trying to follow in what way did I capture the criminal justice system? My misgiving largely was that that point was not canvassed any further here in the commission to then say, but you're making these allegations that this person captured these institutions, because that means all of them are in my pocket, in a sense. But explain to us as the commission as to how this individual, myself, meaning myself, would have gone about capturing these particular institutions. So that was the one misgiving I had, really, to be quite honest, on my side, to then say, but why is this point not further taken up or something? But I'm not blaming the commission, I'm just making an observation about that.
Yes, well, I must say, I don't even remember it being made. I'm not saying it was not made. I'm saying I don't remember it being made. And probably because it's something that affects you directly, you know, but you don't need to refer me to it because your counsel will be cross-examining Mr. McBride and he will take that point up.
Yes.
Yeah.
Just on that point, the Honorable Chair, and I'm sorry, SC, for this. In the communication, the initial communication when I was notified by the commission, in the letter, the commission made the following. You improperly or unlawfully sought to unduly interfere in the investigative independence of the National Prosecuting Authority, the Independent Police Directorate, and the Directorate for Priority Crime Investigation, commonly known as the Hawks. Secondly, you improperly and or unlawfully sought to unduly delay and or decline recommended prosecutions. You improperly, that's the fourth point, or unlawfully sought to participate in the undue persecution of officials in the NPA, IPID, and the DPCI. The last point, raised in the Commission's correspondence, you improperly and or unlawfully sought to destabilize the NPA, IPID, and or DPCI. Now, and therefore my point earlier on.
You are reading from correspondence from the commission.
That's the correspondence from the commission.
From the commission.
Yes.
Well, I just want to say, I don't see all the correspondence that goes out, and actually it's right that way, that I shouldn't see, because otherwise I would not be able to do anything else. But
Oh, it's actually referring to the rule 3.3.
3.3.
yes, no,
Actually, those rules were written, they were written in a standard, it was just a standard
yes,
thing, yeah.
but I'm simply saying, I'm expecting that insofar as it was a 3.3 notice, supposed to reflect what is in somebody's affidavit who is said
Yes.
to implicate you. Yeah, okay.
Yes, that was my misgiving.
Okay.
Only to then say, but if these are the allegations that are made against me, why these issues could not then, in arising out of testimonies of people that were here, why were these issues not explored to establish the veracity of these particular matters and so on? So that was the only thing. But I just wanted to clarify that point. Thank you very much.
Okay.
Yes, but the question now, after you've read that, the question will be, did you do any of those things that are alleged in that notice?
No, I didn't, Honorable Chair. I have demonstrated even in the testimony that I led before this commission as to why I did certain things, what informed me, and what were the enabling instruments for me to take certain positions and or action in relation to certain individuals that got affected and so on. So, at all material times, I acted in the interest of both the law and the interest of the public.
Thank you, Chair. I have no further questions.
Thank you very much, Mr. Mkhari.
And we're really indebted, Chair, to the commission and also for giving us the extra 2 days so that we can finish and Mr. Nhleko does not have to do the to and fro.
Yes, yes.
Thank you very much.
No, thank you very much. I think also the commission is appreciative of the cooperation that both Mr. Nhleko and yourself, leading his legal team, have given to the commission. Everything went smoothly. There were no unnecessary interruptions as we were going along, and I think that that was good cooperation. So thank you very much.
We appreciate that, Chair.
Thank you.
Thank you.
I think I have one or two questions I want to ask Mr. Nhleko, and maybe one of them is of clarification. You remember yesterday, I think at some stage, I asked you about a situation where a report has been given, but some investigative work must still be done. So, if there are two reports, one was provided while there was some investigative work still to be done, and another one was given later when there was no further investigative work to be done. Would you take the first one as final report or the second one as the final report?
I'm laughing at the chair because I think we've been revisiting this question quite a number of times.
It's for the last time,
Yeah,
Mr. Nhleko. It's for the last
all
time.
right.
Yeah.
I appreciate that. Again, we would have to go back to the whole question of your second report. What does it intend to do? Is it nullifying the first report? Is it withdrawing the first report? Is it amending the first report? And it is on the basis of that, as a responsible authority, you will then take what you think is the necessary sort of position and action for that matter. So that's my understanding, Chair.
Okay, okay. No, thank you very much.
Maybe the question should be, sorry, Sir President, maybe the question should be, what is your understanding of the legal status of the IPT reports? What weight do they, or do they even have any legal standing? Or is it one of those reports that, as you say, you have experience in government, which you will ask officials, your managers and so on, to prepare a report. If you don't like it, you can say, go back and draft another one. Do they have any legal standing in the scheme of things?
The IPID investigation reports are very serious reports, whichever way you want to look at it, but they are very serious reports. And indeed, that's why I also understand this closer connection between IPID and the National Prosecuting Authorities because of the weight, the investigative reports that they produce from from that end. And I think whether it was yesterday or the day before yesterday, the chair was also trying to delve into this question of what is the actual weight of these reports. And I do maintain they are very weighty, they are very important and so forth. Now, I know that the issue has been, is the 22nd January report a final report or not a final report and so forth. And I maintain that it is a final report. In fact, that standpoint is also going to be corroborated by further evidence that's going to be led eventually before this very same commission about the status of that very same report vis-a-vis the report of the 18th of March. Thank you very much.
Thank you, Chair.
Thank you very much. Thank you very much, Mr. Nhleko, for coming to give evidence. As I said, I think earlier this morning or yesterday, the investigations are continuing. There is no guarantee that we can't ask you to come back, but I think we were able to cover quite some ground over the past, over the 3 days. But thank you very much for coming forward. You are excused.
No, thank you very much, Chair. I remain committed to my earlier standpoint of assisting the Commission.
Yes. No, thank you.
At any given point, if
Yes.
there are matters that you think I can clarify this Commission
Yes, yes.
about in relation to this particular matter,
Yes.
I am available and committed to do so.
Thank you very much.
Thank you very much.
Thank you. I'm going to, Mr. Halley, I'm going to take a short adjournment because I have another witness to listen to.
Yes. Thank you, Mr. Chair.
Do you want to say something?
Well, I was just going to ask that we could be excused,
Yes.
but once you stand down, we'll excuse ourselves.
Well, I think if you are able to collect whatever you need to collect while during the adjournment, feel free, you are excused as well.
Thank you, Mr. Chair.
And then I will remain with Mr. Noche and a few people here.
Thank you, Mr. Chair.
Unfortunately, the lucky ones will leave and the unlucky ones will remain. We'll take an adjournment up to 10 to 4. We'll resume at 10 to 4. We adjourn. that you are here, and I don't think we are going to take long. So the commission really apologizes for any inconvenience, Mr. Blake.
Thank you.
Thank you. Thank you.
Chair, the witness we are calling, the genesis of his evidence is the evidence of Mr. Agrizi. The
Yes.
chair will remember, Mr. Agrizi referred to the fact that there were certain bookings that were made for persons outside Busasa employ. And he gave evidence to the fact that
Well, I think you should start by saying that Mr. Blake, indicating the relationship between Mr. Blake and Blake's travel, and then, of course, then what Blake's travel was to Busasa and what Agrizi said, and then that connects with how come Mr. Blake is here.
yes. Chair, I'm just getting there that Mr. Agrizi referred to some travel arrangements and made by a company called Blake Travel, and that these were the travel arrangement and expenses for Busasa, the company, and also travel arrangements that were made for people outside Busasa. And as a result of that, the statement was made and obtained from Mr. Brian Blake, who is before the commission today to testify. Mr. Blake is the managing director of Blake Travel, and he's given a statement, and he will confirm the statement, and most importantly, he will also inform the commission how he came about to also contact the commission. And his statement and the invoices relating to the evidence are contained in bundle D. I understand the bundle is before you. And the statement is exhibit T18. Chair, you will notice inside once you open bundle D, you will notice that then the index, there's an index, and then outside the index, there's the pagination. The pages start with T15. That, Chair, refers to this exhibit was initially T15, but because of the changes in the previous hearings, it has been moved to T18. And we have kept it as at T15, the pages, just to avoid expense of printing other pages, but the page numbers remain the same. So when we refer to witnesses, we'll refer to BB and then the number.
Well, you remember that when you refer to the pages, we don't even mention the letters, and the zero, we just say page 1, page
The
2,
number
page
itself,
3.
yes.
Yeah, the red
I'm
numbers at
just
the top.
mentioning to correct the issue of T so that it doesn't
Yes.
throw anyone off.
Yeah, okay, all right.
Chair, Mr. Blake is ready to take the oath, and then we'll
Yeah, but basically, Mr. Blake's evidence follows up on Mr. Agrizi's evidence, part of which was that Busasa and other companies under Busasa used Blake's travel, a travel agency, for making travel arrangements and accommodation. I don't know whether also accommodation.
the accommodation expenses as well.
Accommodation, and that some of the persons for whom traveling arrangements were made by Blake's Travel were persons who were in government officials, and that some of them and all the traveling expenses that were incurred were paid for by Busasa, and Busasa, I think, kept an account with Lakes Travel, and the persons that Busasa asked Lakes Travel to make arrangements for would not pay Lakes Travel themselves, but Busasa would pay for their traveling. That's my recollection of.
Yes, that
the
is,
evidence,
that is
yeah.
correct, Chair.
Yes, and
And
Mr.
Chair, the Busasa kept an account
Yeah.
with Blake Travel.
Yeah.
But in addition to the Busasa account,
Yeah,
Mr. Agrizi also had an account,
yeah,
which later changed to a Fenta account,
yeah,
which, as Mr. Agrizi has testified, it was the name of his father-in-law and
Yeah.
then later his mother-in-law.
yeah,
And,
yeah,
and then the invoices will be issued for those people,
yeah,
but the payment will be made by Busasa,
yes,
either in check or in cash.
yeah. No, that's fine, and Mr. Blakes will correct any of the things that we have said if they are not correct.
Yes.
You can administer the oath of affirmation.
Sorry, Honourable Chair.
Yes,
I'm actually Alderman Blake. That makes a difference. I'm Alderman Blake. I have a title, Alderman. I'm not sure in the legal Alderman.
Elderman.
Correct.
Oh,
Chair is a member of the municipal council, of a district council,
what council?
a district council,
A district council.
yes, and they're called aldermen, and
Elderman. Okay, how do you spell it? I just want to make sure, you know, the noise of the aircon competes with
Sorry.
you.
Chair, it's A-L-D-E-R-M-A-N.
Oh, but that's a title.
It's a title like a councillor.
Elderman Blakes.
Yeah, it used to be councillors, but after a certain number of years, you
Yes,
achieve
okay.
alderman.
No, that's right.
Mr.
Okay,
Alderman Blake, Chair, can Alderman Blake move to,
yeah, that's
or
fine.
use that microphone?
I don't know if the other one is working, just, no, it's not working.
Then move
I think
to this
move
chair.
to the other chair. You want to sanitize, I think they want to sanitize the chair first and before you do so. Please administer the oath of affirmation.
Please state your full names for the record.
Alderman Brian Douglas Blake?
Do you have any objection to taking the prescribed affirmation?
No?
Do you solemnly affirm that the evidence you will give shall be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, I truly affirm.
I truly uphold.
Thank you. You may be seated. Yes, continue, Mr. Noche.
Alderman Blake, can you tell the commission what is your relationship between you and Blake Travel Agencies?
My grandmother started Blake's Travel Agency in 1948 after she was mayoress. It was a coal and wood agency which used to sell coal and wood, but after a while the railways came and said, don't you wish to sell rail tickets and sea journeys or voyages back to the UK? My grandfather took over, my father took over, and I took over when my father passed away in 1994. We are part of the Sure Group. My father was very instrumental in getting Southern African travel agents together to help get better deals on hotels, cars, flights, and assistance with having a network of 50+ travel agents.
Now, Sir Blake, you know, today your evidence is in relation to the relationship between Bosasa and Blake Travel. When did that start, that relationship start?
In 1999, 1998, Home Affairs asked us for repatriations, sending immigrants or illegal passengers back to their countries. And those years, Diambu would bring passports and Home Affairs would collect, we had to handwrite tickets those years, collect the tickets and the passport, and we would invoice Home Affairs still on by typewriter. I remember typing out invoices. These passengers were taken to the airport, put on an aeroplane and sent back to their home country. There were a few instances of irregularities. I remember one Egyptian airline passenger running off the aeroplane, endangering traffic and being caught and put in the Kempton Park police station. It was quite easy for Home Affairs those years to take the people from the Lindela captive camp and transport them to the airport to send them back home.
When you refer to Diambu, you mean Jambu, D-Y-A-M-B-U.
Yes,
Yes.
your pronunciation is more, we called it Diambu, but I suppose the African word would be
Jambu.
Jambu, yes.
And that was the previous name of Bosasa, am I correct?
Correct.
Yes. Now, you made a statement to the investigators of the commission, am I right?
Yes, I made
Before you made that statement,
You may keep your mic on. It won't disturb anything.
okay.
before you made that statement, what had happened between, insofar as the relationship between you and Bosasa?
Well, from 2000, when Diambu became Bosasa, between 2000, 2002, 2004, somewhere there, we did not make any statements until 2014, when the investigation actually started. And my final, my signed statement was in 2016.
Who took the statement from you?
Sorry?
Who took the statement?
Colonel Smith, Christoffel Smith,
Colonel Smith of the South African Police?
of the Hawks, yes.
Yes, okay.
Yeah.
And now, how did you come for you to make a statement to the investigators? What prompted you to come out?
Well, in 2014, Colonel Smith came to me with a certain request, and obviously with confidential information, this man walked into my office and asked me for all details on three specific clients, passengers. And I said, well, I can't give you that. Please, you'll have to subpoena that or bring me something from the police. I was duly subpoenaed, and I took the documents to my lawyer, and we agreed to cooperate fully with the Hawks.
And you also state in your statement that, and you know that Mr. Agrizi gave evidence before this commission about relationship between your company and Bosasa. Can you take the commission through that, the relationship, the accounts that were opened?
Well, Mr. Agrizi would, travel agency is quite hard to run, it's not simple. People can phone you at all hours, and this also did, especially when vehicles broke down and guards needed accommodation. And I think it started, well, slowly, but BOSASA began to rely on us because of our, superior travel ability of being able to accurately get good prices, book people, and, when people had to get on a flight, we found seats, different airlines, and it was simple, pick up the phone and book it. We'd get an order number for the official BOSASA stuff, or Mr. Agrisi or Mrs. Agrisi would phone me for the confidential stuff.
Did BOSASA have an account with Blake Travel?
Yes, we had a running account.
Was one account or many accounts?
We had the BOSASA accounts and we had the BOSASA VIP account originally.
BOSASA?
VIP.
Yes. What was that for?
That was basically, I think, at the beginning that Mr. Agrisi kept that account for very important persons.
Will payments for the bookings made through the account, who would make those payments?
First of all, it was BOSASA paying us with 2 checks in those years, in the beginning years.
Yes.
And then Mr. Agrisi paid with his American Express card. And then it changed to the cash bookings.
Now, you have said to the commission that initially it was BOSASA VIP account. Did it change? Did the account change?
Yes,
To what? To what did it change?
it was BOSASA VIP to Angelo Agrisi, to C. Fenter, to JJ Fenter.
Now, can you turn to the bundle before you, bundle B, page 2.
All right.
Now, paragraph 6 to 9. In paragraph 9, you're telling the commission that after Agri's state testimony, you contacted the commission and you told it that there are certain invoices you have in your possession. Is that correct?
Correct.
And then you say you handed over the invoices to the commission. Is that correct?
I handed over relevant invoices and documents. There still may be further documents that the commission may need.
Or there are still other documents that may show different people who traveled.
It's very difficult, Judge, because we don't know who works for the state and who doesn't work for the state, or who.
Yes, yes.
We have quite a bit of data, but we
Yes.
haven't really had a good investigation, thorough investigation into it.
Okay.
Judge,
So, but you have documentation, invoices and so on somewhere, which if looked into, could well reveal
Further-
people that have not been mentioned.
Correct.
Okay.
It could be possible, yeah.
Okay.
Can you tell
I think that must be explored, if possible, to see whether we can't unearth some more people. So that can be explored, that should be explored in due
Fully.
course. Yeah.
Now, also, Mr. Ray, can you also tell the chairperson about what you did to maintain that record accurate and safe?
Yes, Judge. It's quite a difficult story because we had an investigation with Colonel Smith from 2014 until 2016, till I actually signed the affidavit. And I was ready to appear with Advocate Cook in court in February 2016, and the case just disappeared. Colonel Smith came to me and said, I'll probably I'll probably testify in 10 years' time, but he's been told the case is now flagged. But his direction was for 3 passengers, the 3 mentioned in the report. But there's a lot of other people. We don't know. We don't know if those people are involved or not. What happened thereafter, once Mr. Greasy began testifying, I tried to get hold of the Hawks, and I was told that the original cloning of my server was stolen, it disappeared. There was a guy called Bertus, and eventually I couldn't get hold of Colonel Smith, and I eventually got hold of one of the Hawks in Pretoria who came out and recloned my computer in February.
February 2020.
Yeah, this year.
Mr. Blake, this is important for the commission. Just to explain this, you're saying that when initially you were contacted by Colonel Smith, they took and cloned your hard drive so that they could see all the invoices that were made, and they took that away.
Yes, both in 2014 and in 2020.
And then you say that
Yeah.
when you made inquiries after Mr. Agrizi testified, you found that that evidence had been destroyed, had gotten lost with the Hawks.
I don't know. I spoke to Colonel Smith again, and he said, no, that evidence couldn't, it's impossible for that to happen. I have contacted him subsequently, and he said that is locked away with the Supreme Court. That evidence is locked up.
But and then also you say that insofar as that evidence of Colonel Smith, you were conducted and you were supposed to testify as a witness in that case, but in the end you never testified.
Correct.
So the documentation that you gave to Colonel Smith, would it relate to traveling arrangements made under the account of Bosasa, or does it involve other people's accounts with Blake's travel?
Chair, it was specifically for Mr. Mati, Ms. Nchanda, and Mr. Gillingham. Lieutenant Colonel Smith's focus was on those 3 passengers and their families.
Yes.
Obviously, there were other people, but
Yes, but
his focus was totally
all under the Bosasa accounts.
Besosa or Besosa Associates. Yeah.
Yes, that's what I'm talking about. So I think we should try and do whatever we can to be able to see if we can get those invoices so that we can see whether there are people from government that whose names have not been mentioned here, who also traveled and got paid for by Bosasa. So we should pursue that. So you don't have that documentation with you because it was taken by the Hawks?
No, we still have that
You have got
document.
that?
We've still got it. Chair, also, I had on the 14th of September, I appeared at a tax inquiry, which also asked me for documentation, which I gave through lots of invoices for them to follow up. There's 40 million rands of travel over 6 years is...
That's involved there.
It's a lot of work, yeah.
Yeah.
It's a lot of...
But also, Mr. Blake, just to also make it just clear, when you talk about the evidence that the police took away, it's just the cloning of your hard drive. The hard drive, you still have the original hard drive.
Correct.
Yeah, then the investigators should just do something to check how far we can go in trying to get other names of government people or politicians who may have traveled under the Busasa accounts at Blake's Travel.
Yes.
Yeah.
Also, Chair, when I spoke to Colonel Smith, there were other travel agencies involved.
Oh, is that so?
Yes.
Which were paid for by Busasa, where Busasa had accounts.
There's also Dr. Smith or...
Yeah.
I remember,
Akrizi.
I remember a receipt made out with no name on it.
Okay.
Or-
Okay. I think that's important. If the commission investigators, you can share that information with them when they talk to you. It should be taken further.
Okay.
Okay.
Now, Mr. Alderman Blake, can you then, whilst we're on page 2, can you just read it for the record, paragraph 11, where it deals with your operations with Busasa?
Well, it doesn't have to read it, Mr.
Just
No,
the,
Chair, you can ask him the question. He knows these things. He knows that it's his business. He has been doing it for a long time. He will just tell you.
from this paragraph, it is clear that the first thing, the main account opened was for Busasa Operations Pty, that all right? Is that right? That's correct?
Which was also Pty Limited, yeah?
And from my understanding of your evidence is that that was for the operations of Busasa.
The general operations of meetings, of people, of detainees, of guards, of accommodation.
Yes.
Yeah,
And then you say that, then there was a second account which was opened in the name of Busasa Operations VIP, the one you talked about, the VIP
Correct.
account.
correct.
And then you say over the years, then this changed from the Busasa VIP to the personal account of Mr. Agrizi.
Correct. Mr. Greasy asked me to change it to his name.
And then 2009, it changed to the name of C. Fenter.
Correct.
And then 2012, C. Fenter was closed, and then a new account of JJ Fenter.
Correct.
So the invoices you issued, were issued by Blake Travel, will be to these, for VIP travels. It will be to, the invoice will be VIP, and when it changed to Agrizi, Fenter, C. Fenter, and JJ Fenter.
Correct.
Now, if you can turn back to the beginning of Exhibit 18, there is an index, Chair.
At the beginning,
At the beginning, there's an index. It says Index Exhibit 18.
yeah.
There on item 3 to item 22 of that index, what is indicated in those items from 3 to 22?
Why don't we go to the page where they are?
And they start from page,
Is it 56?
let me, before I even go there. Mr. Blake, you have just confirmed that you did issue invoices for a number of people.
When you always issued an invoice, Chair, it was standard procedure, it was VAT or non-VAT related. It was always to either one of the companies of Busasa or to C Fenter or JJ Fenter. The record is quite nice in that sense that it is quite accurate, because on the invoice is also the reference number to the hotel or the car or the air ticket number.
If we let's take one invoice, Annexa BB4, starting from page 56 to 57.
I've got big fingers, I'm sorry. There we go, okay. We have an invoice number BT 22804.
Yes, on page 57, and this is the invoice is to Mr. J.J. Fenter,
Correct.
and that is,
Let's start by saying it's on the letterheads of Blake's Travel Agents Pty Limited, is that right? Alderman,
Correct. Yes, Chair, and it's got the VAT number.
yes, and it is made out to Mr. J.J. Fenter.
Correct.
Yes, you can continue, Mr. Noche.
and
I
what is
think
this
you can go
invoice
to
for?
the date and so on and the amounts.
And the date of the invoice,
That's the invoice that's tax dated the 27th of January 2016.
and what is the invoice for?
Invoices for accommodation at Sun City, Sun International Hotel, The Palace.
And then who,
I'm sorry. So does this invoice reflect that Blake's Travel had made the booking for somebody to stay at Sun International Hotel, The Palace? Is that right?
You not always, this one is a little different. So remember that I think it was Mr. Glamini who made this reservation and we took it over. Often somebody will say, please just hold the room for us. And then we'd phone in and say, right, we're taking over, we need your bank details, we'll pay by credit card or we'll pay you by EFT.
You say it was Mr. Dlamini. Was that supposed to be your client?
Mr. Sivian Glamini worked for this.
Sivian for Sivian Dlamini for
Yeah.
Busasa.
Correct.
So he had made, initially he asked your travel agency to make a booking.
Take over the booking.
And was that in respect of himself or in respect of somebody else? Do we see
I think
here?
it was first in the name of Mr. Papi, and then
Mr.
it was
Bopapi.
changed to his secretary, Jade Oren.
Oh, okay,
I presume that was how
okay.
it was a sort of an emergency case where Sun International doesn't just hold rooms, you have to pay them. You know, they're quite very tough on,
Yeah,
and we paid them and
Yeah.
we invoiced JJ Fenter who paid us.
okay. Mr. Nosh.
yes, and then the amount of the invoice is at the bottom is 60,178 rand and 89 cents, am I correct?
Correct?
And then you paid Sun International, and then how were you paid?
I was paid cash by Mr. Greasy from JJ Fenter. All JJ Fenter invoices were reconciled and cash was collected for this.
And then the next invoice is on page 58. Actually, the invoice itself starts on page 59. Is correct, the invoice is in the letterheads of Blake Travels, in the text invoice by Blake Travel.
Correct? It's our invoice
Yes, to whom is it invoiced?
to Mr. K. Mokanyani.
And what is this invoice for?
Well, the invoice is to Busasa Operations Pty Limited, isn't it? It's directed to them.
Correct.
Yeah, but in respect of,
Budget car hire, the car rental.
yes, for whose benefit?
It says for a Mr. K. Mokanyani,
Okay,
but sometimes the people get it wrong when the invoice.
would that be a miss?
It could be.
Yeah.
Judge, what happens is we would give a voucher through, so there's a whole lot of documentation that goes with this. It's a car voucher. It would then be rented out. The bill would come back to us, and then we would do this invoice after we'd received the bill.
Okay.
So it could be that the car company made the error and we just did the invoice after that. But the person renting the car would have had to give their ID and their driver's license.
Now, on the following page, on page 60, there's again an invoice by Blake's Travel Agency and to Mr. J.J. Fenter. And this is for budget car, and the description is Ms. K. Mukonyane for the amount of 517.
This chair relates to traffic fine.
And who paid for this?
It was Mr. J.J. Fent, well, Mr. Greasy through cash to J.J. Fenter's account.
And then the following one, at page 61, is again an invoice to Ms. J.J. Fenter. The driver is Ms. K. Mukonyane, and the amount is 287 rand.
Again, a traffic fine. Also paid by Mr. Greasy cash through his J.J. Fenter account.
And then the next one is,
You may, I think you, for the sake of completeness, we can cover the charge as well, to say it was on that date, addressed to so-and-so, in respect of so-and-so, and this was the charge. So it makes it easier to know what was spent on a particular individual if there is a repeat.
Chair, will it also make it easier if, instead of going through these invoices, if the chair were to look at starting from page 32. Page 32 has a spreadsheet of the amounts paid and the people paid, and it then in one place covers the expenses that were paid by Blake Travel and then compensated by Busasa. Now, Chair, this spreadsheet is then backed up by the invoices that I was taking the witnesses through.
Okay.
So
that's
it can be safe if one goes through this spreadsheet,
yeah.
knowing that
Yeah, that
this is
backup.
covered by the invoices.
No, that's fine then.
Mr. Blake, just to put it on record, just go to page 32.
All right.
Just put your hand on page 32, and then this goes up to page 55.
Right.
And now, am I correct to say that this spreadsheet is sort of a summary of the invoices that were issued by Blake Travel, and it sets out the service provider, the invoice number, the date of the invoice, the addressee, the person to whom the invoice was addressed, the description of the invoice, and the amount, and then at the bottom, at the right end, it tells the commission where the invoice is in the bundle. Am I correct?
It's a very good summary, Chair, of the clients that we've identified, but there may be further people on that JJ Fenter account that they've fallen through the cracks, Mrs. Jackford.
I see. But for now, what is on page 32 to page 55 is covered by the invoices that are in this file.
Correct.
Now, in order to save time, but still maintain the evidence, I will just refer you, like you to, just to read, the total, you know that there's the item number 1, we have dealt with it, is to demonstrate also for the chairperson. Item number 1, the supplier is Sun International, is the invoice we had looked at. Then there's the invoice number, the date of the invoice, and the invoice was, your invoice addressed to JJ Fenter, and the description is Sun International will tell the palace, and then the number, and then the dates, and then is the guest was JD Orex, JD
Orange.
Oren,
Yeah.
and then the amount is 60,178 rand 47 cents.
49
correct?
cents. 49 cents, yes.
49 cents, is that correct?
Correct.
And the invoice is the one we went through.
BT 22804.
Yes. And then the next person is Katlewo Mukonyane. And there the supplier is, in all the items, is the budget car. And you have under the invoices, invoice numbers, and then the dates of the invoices. And then the invoices are addressed to Busasa Pty on JJ Fenter. And there are a number of items, and the total amount is 69,497 rand 25 cents. Correct?
25 cents, yes.
Now, Mr. Blake, where the invoices are addressed to Busasa operations, who paid for those invoices after you have paid them?
Bosasa would collect all the invoices under Bosasa and pay us monthly by EFT.
You paid by Busasa directly.
Correct.
And then the ones for JJ Fenter?
JJ Fenter was also lumped together in months or 2 months or 3 months and paid cash.
I see. And then below that, you have the invoices for Mohammed Murad. Before that, Chair, can we go back to, do you know who's Katla Homukonyane, for whom the Busasa and JJ Fender booked for?
I remember one of the girls in front was saying that they desperately needed a type of a car for the minister's daughter. So she managed to get the car through budget car hire because none of the car hire companies actually had that car that they were looking for. So I guess they sort of knew it was important to get a car for this person because Bosasa was really wanting us to find the right vehicle, yeah?
And then we saw, when we were looking at the invoices themselves, that there were the amounts of 517 and the amount of 287 were fines.
Correct, they're traffic fines. They would come through budget car hire or the car hire company. And obviously the traffic departments find the car hire company and then pass the bill on to us.
And then, but for those, Mr. Agriz paid cash for those.
Paid cash for those, yeah.
And they were not paid by the person to whom.
No,
The car had been
the
hired.
cash would have been, if there was an invoice for it, it would have been tallied and paid by Mr. Agrisi or Mrs. Agrisi,
Yes.
cash, yeah.
Now, then the next person is Mohammed Murad. Do you know who this person is?
No clue, sorry. I reckon that if I know or if I've met 30% of my passengers from various companies throughout the world, that's doing well. But often companies will ask us to book for individuals. We get a copy of their passports quite often, and we'd make reservations for them, but we'd never meet them. You know,
I see.
we're in the electronic age now. We're not in the old travel agency, walk in, have a cup of tea and discuss a cruise. It's get me on an aeroplane, get me this hotel, get me that car. It's,
But in a situation like this, where the booking is made under the name of JJ Fenter, who would then give you the name of the passenger or the person for whom the booking is made?
it would generally really come from Mr. Greasy or Mrs. Greasy. And it would either be SMS or phone through. But we would have to check the spelling very carefully.
I see.
Yeah.
And then there is the 2 bookings, and the amount is 3,351 rand and 44 cents.
Correct.
And then the next item is for Dudumieni and Co Travelers.
Right?
And these invoices, all the invoices seem to have been made by Mr. JJ Fenter. The invoices were made to JJ Fenter.
Correct.
And the invoices on this spreadsheet starts from page 32 up to 33, in the total amount of 101,000 rand 718 rand 3 cents.
Correct.
And then when we look at on page 32, when you look at the description, it says Dudumieni and Co Travelers. And then there's a description of Sheraton Hotel, PTA, and then guests Dudumieni, Catherine Dawson, and then on the same column is Dudumieni, Duduzeli Mieni, Catherine Dawson, Sheraton Hotel. And you say these names will come from Mr. or Mrs. Agrizi.
Correct. The PTA stands for Pretoria, so that's the Sheraton Hotel Pretoria.
The PTA.
Is Pretoria.
Oh, I see. And then over the page, we see again, there is Sheraton Hotel, Pretoria, Dudumieni, Catherine Dawson. And then the following one, which may explain other items, it has got TIC, like a ticket number, there's a number. That's a ticket number on item 3.
Yes, that's a ticket number.
And then passenger Catherine Dawson, and then route JNB MQP Nelspruit. Is that the route Johannesburg to Nelspruit?
Correct.
And then there are a whole host of other items up to item 22.
Correct.
Chair, I will not waste your time to refer to it, but they are referred there by the witness. And then over the...
I don't remember that you asked me to admit his affidavit.
Chair, I would, I was hoping at the end after he has testified, to confirm the correctness of the affidavit.
Let's do it now.
All right.
Mr. Blake? The affidavit of Mr. Brian Douglas Blake, deposed to on the 28th November 2019 will be admitted and marked as exhibit T18.
It's bundle.
Is it still T18?
It's in bundle G.
No, the exhibit is different from the bundle.
T18.
Yeah, T18. Okay, all right.
Together with the annexures.
Yeah, together with its annexures.
Yes.
Okay. Important to also mark on its face at the top, exhibit T18. Yeah, so that it's known that that is Exhibit T18
At the top of,
at the top of the first page of the affidavit.
oh, I see.
Exhibit T18. I think when it's done, so you can mark the one that is with the witness later on. Okay?
Now, Mr. Blake, we were on page 33,
Right.
and then there is then the heading of Trevor Forey at the last entry on page 33.
Page 34.
No, page 33, start on page 30 at the bottom.
Right at the bottom.
On the
Yes,
blue.
Trevor Fourie, the heading, yes.
Trevor Forey, and then the invoices in relating to Trevor Forey. They're on page 34, am I correct?
Correct.
And then there is, again, is booked by JJ Fenter.
I'm sorry, I'm at page 33, but
At the bottom, at the foot of page 33, Chair will notice there is
In blue, Chair.
the entry in blue on page
oh,
33.
okay. So I think I'll write here because the rest relating to him
It's on
is
page
on the
34.
next page. Trevor Forey. Yes, okay.
Mr. Blake, if one goes through all these, the spreadsheet up to page 55, one will follow is on the blue, is the name of the person who the booking was made for, and then the details of the booking follow that, and then at the end of that column will be then the amount, the value of the entire booking.
That's correct. Yeah.
And as we had said previously, and then that is backed by the invoices that are attached to your affidavit.
Correct.
Now, on page 55,
I'm sorry, did you say 55?
yes, Chair.
Can we go back to 35 before we go to 55? Alderman Blake, if you look at page 35, you will see that in the middle, you have got the name C. Frolick. Can you see that?
Page 5,
Page 35.
85.
No, 35. On the, look on page 35. Look on the blue,
Page
separation.
35, 35.
Yeah,
35.
35, apology. 4. 85, all right?
35, right?
Correct.
Yes, can you see the name Frolic, C. Frolic there?
Correct.
Do you know, would you know what the full name is, or would you just know C. Frolic in terms of your company with somebody, with a guest?
No, Mr. J.K. Watson told me his name was Mr. Cedric Frolic.
Mr. Cedric
Yeah.
Frolic. That's what you were told when they were booking.
When they're booking, yeah.
Okay, all right.
It should appear on the hotel invoice as well.
Yes, yes.
And,
You don't remember any other Frolic that you might have? It's just
No,
that it's-
he was
only this
quite tied up with the Eastern Province Rugby. Yeah,
Yes,
yeah.
yes.
Yeah.
Now, I see that when you look under his name there, there was a booking for him at the City Lodge or Tambo on line Club for the period, for accommodation for the period 10 June 2010 to 12 June 2010. And then the next booking was at City Lodge OR Tambo, and guest says Mr. C. Frolic. Then the accommodation then was for 21 August 2010 to 22 August 2010. And then all these bookings appear to have been connected with rugby. The third one is for Frolic C on 10 December 2010 to 12 December 2010. Excuse me. And then the next one is, why does it look like there are 3 which have the same date? There is the third one is 10 December 2010 to 12 December 2010. The next one is for the same accommodation. The third one is for the same accommodation. Does that mean he stayed or consecutively on those days, for those days, and if, or there was an extension, or what, why do you have it that way there?
I'm not sure, Chair, we'd have to check that.
Yeah, but you see what I'm talking about.
I see that, yes.
Yeah.
Chair, will it help if we turn to page 114,
114,
114?
okay. Yes,
These are the, starting from 114, these are the invoices of Mr. Frolic. Am I correct? Alderman?
yeah,
Starting from 114.
well, the dates are the same. And I don't know if
Look at what the chair is referring you to is
the place is the same as well.
on page, it starts on page 116 and 117. What the chair is referring to is there is, the date is 23 December 2010, and the town lodge, Mr. C. Frolic. And at the bottom, if you look at the description, the date is the same.
It could be, Chair, that there could have been more than one room booked in his name. That's why we must go back and check the invoice from the town lodge in George to see why we invoiced. Because we would invoice against a invoice from the town lodge.
So it could be that he booked 2 rooms.
2 or 3 rooms.
Or 3 rooms, okay.
Yeah.
Okay, all right. I think it would be good if that clarification can be obtained. Okay, all right. Okay, that's what I wanted to check but that, yeah, that total, the total for him at that page 35 is 13,990 and 44 cents. Okay, I think we can continue.
Thank you, Chair.
Yeah.
Chair, the evidence I've led so far was merely to demonstrate how one can navigate through the spreadsheet.
Yeah.
With your leave, can I take the witness to page 55?
Yeah, that's fine.
Alderman, can we go to page 50?
Okay,
Page 55, and at the bottom, the last entry there is the total amount that was booked for by JJ Fente or Busasa. And that amount, if I say it, amounts to 1,234,481 rand 11 cents. Is that correct?
that's correct. But you must also remember that the JJ Fenter account,
Beg your pardon?
yeah, Chair, the JJ Fenter account, Greasy actually thought that it was his account.
Okay,
So a lot of his private stuff.
yeah,
So over the period, it was closer to 4 million than 1.2 million. But a lot of it was, you know, family and
yes,
not,
yes,
but there could be stuff that we
Yeah.
missed, yeah.
yes.
But the 1.2 is in relation to people who are not Mr. Agrese's family.
Correct.
And these people, the people who are appearing on the description of the invoice did not pay for this, but Mr. Agrese or Busasa paid for it.
Correct. Cash, yeah.
See. Now, there is also an item that I would like you to tell the commission about. It's Mr. Agrese, in his statement, he gave evidence to the effect that when there were problems, he came to your company and then actually you deal with it on page 21 of your statement.
What page?
Page 21. Chair.
21, okay.
right.
Yeah, continue.
Okay.
And you say there that you heard in the news that Mr. Agrese says that you came to your company and took 5 computers of Blake's Travel and buried them somewhere.
Yes, Chair, yeah, that had me worried because I couldn't figure out how I could do that. First of all, we've proven that none of the evidence, we still have the evidence on our computers. B, if you do take a travel agent's computer, you have to reprogram it with certain items, and you have to have a certain IP address, and you have to have an email address, and it's just nonsense. There's no way that that could have happened. I just cannot, even my IT expert made a statement to say that that's impossible.
Is it possible that certain computers were taken and were buried somewhere, destroyed and buried somewhere, but that did not necessarily mean all that information that was in the computers was lost? You still could get the information technologically?
Chair, I think Mr. Agrese must, that was not his only statement. I heard he also buried computers in Port Elizabeth and a couple of other sort of things too. So I think he forgot. I think he didn't tick the box. Because he might have buried the Basosa computers there, because I know they were changing invoices from what I hear afterwards. But no. You're welcome to have a look at my computers. They can go back, they can check them. None of my staff remember ever getting new computers. I mean, surely they would know they got a new computer. Just highly, highly unlikely. And welcome to come and check and prove it. And then, why have I got all my invoices? Will you take my server if you wanted to destroy evidence? Yeah. Yeah.
So that should be taken further with Mr. Agrese. That should be pursued with Mr. Agrese to tell
That
him what...
his evidence is refuted by.
Yeah, and hear what he has to say, yeah.
I see. Thanks.
Thank you.
I think he just forgot to tick the box, huh?
Okay.
You know, he was this and that and destroy this and do this and do this, but, you know, when they raided Bosasa in 2006, they didn't come to me, but they took all the Bosasa information,
Yeah,
didn't come to me, only in 2014. Yeah.
okay.
Now, on page 15 of the recording of your statement, you sort of deal with the issue that was raised by the chair,
On what page?
page 15.
15, okay. Well, before we proceed, I think I've got to ask this. Alderman Blake, you know, from page 44, to page 50. There are the name LMT appears very frequently. I mean, Mr. LMT, Mr. LM or Mr. RMT must be appearing, I'm taking a guess, more than 20 times.
Perhaps 100.
What must I make of that? That he was traveling a lot under the Bosasa account?
From what I understand, Chair, Mr. Mati, as Mr. Richmond Mati, which is as Mr. Greasy referred to him, is actually Mr. Desmond Linda Mati, which was referred to me, plus his history was given to me by the Lieutenant Colonel. It's quite interesting. But yes, very much Mr. Greasy would phone me with the family in Port Elizabeth, the flights to Port Elizabeth, the car hire.
I say 20 times, that might be an underestimation.
less.
Might even be 50 times, I'm not sure. It's,
Chair, it goes to 138 times.
eh?
138 times.
It appears 138 times.
Yes, Chair.
That
And the
does
total
not-
amount, am I correct? The total amount is 796,867 rand 52 cents
Is that what,
on page 51.
okay, what you paid in regard to Mr. MT?
There's probably more,
There's probably more.
because these are only from 2015. I'm not sure if there's,
Yes, there may be a lot more
yeah.
before that.
yeah, but at least that amount, yeah.
And I think he left correctional services, if I recall the evidence of Mr. Agrizi correctly, he left correctional services around 2007, 2008, or 2006 or thereabout. But of course, I think it may well be that the relationship between Bosasa and him continued.
I think Mr. Watson relationship
Yes,
is
and Mr.
quite
Buya.
well determined by Lieutenant Colonel Smith back to the
Yeah.
UK. Yeah.
Okay, all right. Mr. Noche?
Actually, whilst on that, Chair, it's on page 44, Alderman, You'll see there, the heading is Mr. Lindam T and Ms. T Njana,
Correct.
all right?
Correct, yeah?
And then if we turn to page, oh, the reason is the reason why you mentioned those together, were they traveling together?
No, Ms. Nachana is actually his wife, but under custom. Ms. Nachana was advised to me to be a CETA officer as well, working for government. I think the name was still in the passport as Nachana, that's why we
Yeah, you
kept
used it.
the
Okay.
And then on page 51, you then see again Ms. Njana standing alone. And then those bookings, there are about 36 of them. They amount to 172,962.52 cents. On page 53.
What's the total? Page 63,
No, 53, Chair.
53.
53
Oh,
is 172,962.53 cents. Am I correct, Alderman?
that was for Ms. T and Chana.
Mr. T in China, yes. And then again, you see the name of Mr. Lindam T just below the Lindam T, Ms. T in China, T Lebello. Then their expense goes over the page to page 54, and the amount there is 171,992 rand 6 cents. You confirm that?
Yeah, 171,992.06, correct.
but as you say, it could be more.
It could be.
Yeah.
It could be.
Okay.
Now, if we go back, Chair, to on page 1515, I just wanted to clarify, there's an issue which was raised by the chairperson regarding the traveling of Mr. Frolic.
Yes.
You're saying there in your statement that the first 3 invoices were paid by Eastern Cape Rugby, but you say you are not aware of the internal arrangements between them and Mr. Frolic.
There is an email further on which I think sort of says that Mr. Watson didn't want Eastern Province Rugby to pay for it, but for Bosasa to pay for it.
Just repeat that. Who paid for Mr. Frolic?
Originally, it was Eastern Province Rugby.
Yes.
I think the invoice was made out to them.
Yeah.
But further down the line, there's an email from Mr. Watson asking Mr. Greasy to pay for it.
Is the email in this bundle?
I think it is.
Can you look at page 14?
1-4.
1-4.
Does it start somewhere?
Is this the email on paragraph 28.6?
Yeah, I mean,
that what you're talking
this
about?
document,
Yeah.
where does it start? Let's go where it starts first, the document. The document at page 13. It looks like it's a continuation of a document, isn't it?
Is on page 14, Chair, he's discussing invoice 27255.
Yes, but what I want is, where does this document begin?
The document we're looking at,
Yeah.
this is his affidavit.
Oh, this is part of his affidavit?
It's on page,
Oh,
it starts on
okay.
page 1, yes.
Okay, and what paragraph?
Now, it's on page 14, paragraph, here he's discussing invoice 27255, and then he explains on you're on paragraph 28.6. Then he says, in respect of invoice 27255, I have provided the commission with the email correspondence which is attached as BB111. Certain extracts from the email are as follows. From Jürgen Smith, sent 14 December 2010, 05:11 p.m. to Angelo Agrizi, subject, forward invoice from Shaw Blake's Travel, Pty Ltd, attachments to be email PDF. Then inverted commas, Angelo, Chiki told me that this invoice must also be paid by Busasa. Please advise, Doc. Is that the invoice, the email we're talking about?
Yeah, that was the email where Cheeky was asking those invoices to be paid by Busasa.
Do you know who is being referred to there as Cheeky? Or would you not know?
Cheeky Watson.
Cheeky Watson. Yeah, he is Mr. Gavin Watson's brother.
Correct, from
Yes.
Eastern Province Rugby.
Okay, so this email was from Mr. Jürgen Smith, who was part of Busasa, addressed to Mr. Agrizi, and telling Mr. Agrizi that Mr. Cheeky Watson had told him that the invoice should be paid for by Busasa. That's what it says, eh?
Correct.
Okay, cool.
And then did Busasa pay the invoice? Do you know?
I'm not sure. We're talking 2010. I would have presumed that we would have had to re-invoice it and change the invoice. So it's, or it could have been that cash was given for that invoice and just squared off.
I see.
We'd have to check it.
I see. And now, and then,
You may not be able to say anything about this. I understood, I think from either Mr. Frolik's affidavit or from someone else's affidavit in this commission, that some of the trips that were being said to have been paid for by Busasa in respect of Mr. Frolik in Gauteng were for him when he came to Gauteng to attend rugby. So, but I see that here, it looks, in 2010, it looks like it was for the Soccer World Cup.
It was for the World Cup.
That was for the Soccer World Cup.
Correct. In fact, there's more documentation that Mr. Nixon asked me for, which is investigating.
Oh, is that so? So could we have that?
I've sent it to him already.
Yeah, is that one of the investigators, Mr. Notch?
Mr. Nixon is one of the investigators, yes.
Yeah, he's looking into that.
Yes, okay.
Okay, all right. Okay.
This is, Chair, on when there was a follow-up on the statement of Mr. Frolik about the traveling to Port Elizabeth and
Yes, yes.
is the follow-up.
Yes,
That evidence will be presented before Mr. Frolik testifies.
yes, no, that's fine. Can I also check whether there might be any chance that your records could still have whatever bookings may have been made for Mr. Agrizi? I don't know whether it was in 2010 when he says he traveled to Port Elizabeth to meet with one of Mr. Gavin Watson's brothers and Mr. Frolik. If it's 2010, your records could still have that.
Yes, we would have had invoices to it. I did note that in 2010, because it was World Cup,
Yeah, you would still have.
VIP Embasasa did not do very much. There was not a lot of activity in 2010 with Embasasa.
Okay.
I think a lot of it was done with FIFA, and
Yes.
I will have records.
You
We'll
might
just have to
You will
check
have
and
the
see
records.
if they were done with us or if
Yeah.
FIFA paid for them. Yeah.
Okay. I think, and the investigators, Mr. Noche, may be working on this, that the trip that may be disputed that Mr. Agriz talked about when he says he went to Port Elizabeth and met with, I don't know whether Mr. Chiki Watson or
It's
somebody
Mr. Valance,
else.
Valanswa.
Yeah, Valence Watson and Mr. Frolik. Yeah. Yes, okay, all right. Thank you.
That's being followed up, Chair.
Yeah. You may continue.
Yes, and on page 16 of your statement, you deal with the booking of Mr. Sivion Dlamini. Are you on page 16?
Yes?
Do you know who Mr. Sivion Dlamini is?
Yes, I've met him.
Who is he?
He stays in Lock Crescent Street, I think, number 8 or close by there. He's a regular from Embasasa.
I see. And I see there's a booking here, but it was also, the invoice was sent to JJ Fenter.
Correct. So a lot of the bookings that were sort of kept hush-hush were JJ Fenter bookings. They were always bookings that were not put on the Embasasa account
I see. And paid for by
by Mr. Greasy.
Mr. Chris. Now, on page 17 of your statement, then you've got a whole list of people. And you say this is a summary of individuals other than the ones you've testified about, and other than Mr. Gillingham and Mr. MT, and then you whole list of them, about 16 of those.
Correct. There's 16 people that appear on the JJ Fenter account.
Yes.
So just to go back to Mr. Frolik, I see from your affidavit that some payments for some of his travel arrangements made through Blake's Travel were paid for by the Eastern Cape Rugby Union. And I see that on some stage, he apparently deposited or dropped a check himself for somebody that I think he may have been with.
Donation for one of the lady rugby players of the Eastern Province Union.
Yes, yes.
He paid for a ticket, yeah.
Yeah, so some payments were originally made by the Eastern Cape
Okay.
Rugby Union,
Correct,
and then, but later on, Bosasa paid for some.
correct.
Okay, all right. From the top of your head, are you able to say whether there were many that were paid for by Bosasa, or you are not able to say?
I'd say, Chair, I think Mr. Daniel Watson, Cheeky Watson, he would get his way with the payments, although Mr. Greasy wasn't very happy about it, because
Yes.
it would come from his account. But Mr. Greasy would probably be able to verify it more than,
Yeah,
I'd have to go back and
Okay.
triple check my books on it.
okay, no, that's fine. Mr. Noche?
Yes. And then the rest of the affidavit, you then deal with your interaction with the bookings of Mr. Gillingham and Mr. MT, and those are also covered by the invoices that are attached and they are also on the spreadsheet. Am I correct? On, so far as Mr. Gillingham is on page 19, you deal with a table that deals with Mr. Gillingham there, is that correct?
Page 19, Mr. Gillingham,
On page
correct?
19.
Yeah,
Is that the table that deals with the bookings of Mr. Gillingham?
correct.
And now who booked for Mr. Gillingham?
Mr. Greasy would have booked for them. I do see one payment was paid by Mr. Mansell, or one or two payments were paid by Mr. Mansell. And others were paid by Mr. Greasy.
Did you receive any payment directly from Mr. Gillingham?
No. No, Chair, we didn't
Chair,
receive
except for the investigations that Chair has indicated, that is the evidence of the witness.
yeah.
I think we have covered the important parts.
Chair, and also just for the record, the people that are mentioned that are affected by the evidence were given what we term the Rule 33 notices in
Okay.
respect of the witness, of this witness.
Okay. Thank you very much, Alderman Blake, for coming to give evidence and for your assistance to the commission. We appreciate it very much. We may ask you to come back if there is a need, but we won't bother you if we've got everything. But from what the queries I've raised, I think probably the commission or the investigators will still be in touch with you. But thank you very much for coming to give evidence. Otherwise, you are excused. And once again, thank you for being prepared to wait for the whole day. But thank you very
Thanks,
much.
Chair. I've been waiting for 6 years to get this thing sorted out.
Thank you very much.
Let's hope we could get it all put to bed here.
Yes, no, that's
Correct.
fine.
Thank you.
I think we'll adjourn then for the day. Tomorrow I have 2 or so witnesses at 10 o'clock, so, but for the day, we are adjourned. We adjourn.